Okay, the next agenda item is public hearing. Dan Dudley is requesting to appeal the building commissioner's enforcement orders dated June 1st, 2018 and June 15th, 2018 pursuant to Chapter 48, Section 7 on property located at 160 Wallis Street, Assessors Map 158, Parcel 19. That announcement was posted in the town hall and published in the Worcester Telegram Gazette on July 25th and again on August 1st. Voting on this case will be Mr. Fitzpatrick, Mrs. Holmes, myself, Mr. Holland, and Mr. Bombara. Is the applicant or his representative?
Thank you, Mr. Chairman.
Earlier.
You did just see me. If you were paying attention, you saw me earlier.
I thought he didn't have so much, I thought he was a new member.
This is where that bridge is, and it goes across. Right?
Yeah.
Over the Slim Bridge.
I was just inquiring as to whether or not, in looking at Google Map, if this area is where the Slim Bridge runs across.
Causeway.
Way.
It's right at the causeway.
Slim
The
bridge.
Slim Bridge was a very slim bridge.
Okay, Mr. Lane, the floor is yours.
How long have you lived here?
Thank you, Mr. Chairman, board members. Henry Lane here on behalf of Mr. Dudley. I'll make this very brief because we know it's been a long night already. Three things, basically. First of all, we need a little more time to get our act together, I guess. There's a lot of questions here. Exactly when some of these buildings were built. We've done some research. We have a little more research to do. There's some question about exactly where the property line is. I know there's been a survey done recently. We haven't seen that survey, so we don't know exactly what the relationship is between the property line and these buildings. So we'd like to get that clarified before we go forward, because otherwise we're just kind of wandering around in the darkness, shall we say. So, you know, rather than doing half a presentation, knowing that we can't complete it, it just seems to make more sense to sort of put this over a month, and hopefully
Continuation.
we'll have a better sense of what's going on. And maybe we can resolve it before then, but in any event, it doesn't seem like we can make any real progress tonight, so we are going to ask that it be continued. Secondly, I know that the board's policy has typically been, and it's a good policy, that they like to see the sites, that are going to be discussed at the various hearings. Unfortunately, this is somebody's home, and we'd really appreciate it if board members, either individually or as a group, would let us know if they're going to come to the property, so that we don't have people wandering around and, we end up calling the police because we don't know who they are. So, if you haven't been there yet and you'd like to go to the property, please let us know so that we can expect you. We won't be serving refreshments.
We call you, or we call?
You can call me, you can call Mr. Dudley, but, as long as we know, so that we don't have people wandering around there. And, some of you may or may not know that we had an incident where we actually did call the police in the last couple of days because there was a board member out there. So, no harm, but nevertheless, it's just uncomfortable to have people wandering around in your yard.
Wouldn't it be expected?
What's that?
Wouldn't it be expected if you applied?
No, I'll tell you, I work with dozens of boards, okay, and most boards go, they arrange a visit. If they're going to do a site visit, they'll pick a time and a date, and they'll let you know, this is the time and the date we're going to be there, that we can be there, and we can sort of say, here's what you're looking at.
In all fairness, I've never even heard it come up since I've been on here since 2013. And I've never asked permission.
I've walked every site that this board has heard in the last 11 years without any issues.
Well,
Every site in 11 years.
I understand it. Every town does it differently, and we have no problem with, I think it's always nice to see that the town board members have enough interest that they actually do go do the site visit and see it.
I'm not sure how you make a decision without doing that, but whatever.
Well, but the thing is, see, there's different ways of doing this. If you're doing a drive-by and you're on the public street, that's one thing. If you actually come onto the property, that's a whole different deal. And we're basically saying, look, if you want to see the site, we're not trying to hide it, okay? We just want to know so that we don't call the police because we see people walking around in the yard.
Maria, do we have a phone number to reach the homeowner?
Sitting right there.
Oh, I just didn't know
Wanna do it
whether
as
we
a
had, whether we have a phone number on
Do it as a
on
group?
file.
I'm willing to give anyone my phone number, my
Okay.
email address.
Okay.
What if we
Very
did
good.
it as a group?
Okay.
Why don't we just do it as a group?
I guess we could.
If I could just, could I say something?
Not yet.
Oh, okay.
Yeah, back when I first got on, there was I ran across a incident where I was a little uncomfortable. The property that I was inspecting was down a dirt road. And I drove down the dirt road, and then probably the husband came home from work, and of course he passes me, and I'm going, he doesn't even know that I'm here, why I'm here, and I suggested to the board that we put on the applications notification to the parties who make any application to the zoning board in Douglas, that if you make this application, be advised that the members will need to come on your property. And, you know, if different people would like to be notified before that happens, that's certainly fine. But but I intend to make sure that that gets put on our applications
Excellent
from now
suggestion.
on.
You don't think that that would amount to some sort of small time taking, Mr. Lane, possibly $400 or $500 worth of value?
Right.
This
Yes.
particular application, to simplify it, I think if I had a plot plan showing the size and location of the structures in question, I don't need to go there. But I don't have anything other than driving to the property and looking.
And you don't have anything because we don't have anything. And we don't have anything because,
Because he's,
I actually went to the property, and the lot line staked out. I don't know by who, what engineering firm, whatever, but it is clearly staked out.
And is the buildings on the other side of the property line?
Yes.
You gotta be moved.
so,
well,
So,
let's not make the
would
decision
the
before
board,
we have the hearing, okay?
Oh, I'm
Would
sorry.
the
He's
board
not
like
voting on
to
it, so you don't
visit
have
the
to
site
worry
as a
about
group?
Hold on.
it. He's just making a comment.
Would you like to visit the site as a group?
If you need me to go, I'll go. But I just need to see a plot plan showing where the structure is, because if we don't have a certified plot plan, and we have stakes out there, and we don't know who put the stakes in,
Right.
who's to say
What they
if we're
are.
in his yard, the neighbor's yard, or whose yard we're in? So I would like to have something with a little stamp on it that shows me where the structure is and what size it is.
Is there anybody else in the room that'd like to speak on this case?
My name is Pat Pollard, and this is my wife Diane. We are the abutters of Dan Dudley's property, and we had the survey done shortly after we purchased the property at 6 Shady Lane. I would do that normally for every house that I've owned. I've only owned 3 homes in my life. One was our starter home in New York when we started out, when we got married. And our second home was in Uxbridge, and we had been there for 26 years almost. And we also had a survey done, because I wanted to make sure that whatever I did and wherever I placed a shed, or that I made sure that I went down and pulled a permit and made sure that I staked out the offsets, and I had to make sure that the structures were inspected and measured to make sure that they were not placed, because I didn't want to be in violation and have someone come back to me later on or have a mess in my hands. And I also wanted to know, what was, on either side of me as well, right? So I did the same exact thing. In retrospect, I really wish I had done it before I bought the property, which is an unfortunate set of circumstances that got revealed. This is my copy of the survey, and it shows my side of the abutter's property line, and it shows to the extent of where some of the things that are now established as encroaching over the property line. Now, that particular survey was at pretty great expense, because it is such a large piece of property. And actually, I had them come back because they failed to actually note all of the encroachments and the exact locations of the encroachments, so I had to pay an additional fee to have the crew come back out from Andrews and actually set that into the current plan. I'd be happy to lay it out on the table if you want to take a look at it. I will say that I'm not inclined to be sharing this with Attorney Lane or with my neighbor at this point, because personally I feel like, and has nothing to do with this particular case, but I get the feeling that we're being bullied. You know, it had this, you know, so I'll just leave it at that. So if you would like to see it, I'll lay it out on the table for you now.
Okay.
And that's it.
Sure.
Yep.
But, you know, if, Mr. Chairman, with all due respect, you know, I know Mr. Pollard's got an attorney who is not here. If we're gonna be sharing documents, we're gonna get copies of them, because if you're not,
I'm
we're
going
gonna
to sit down, sir.
Well, that would be
No,
between
he's
you
just
guys.
gonna show it.
You can show it to us.
We're not gonna show exhibits that we're not gonna get copies of. It's just not gonna happen. We're gonna subpoena those
So,
documents to
Attorney
the
Lane,
next
I would
hearing.
suggest that you suggest to
You know what,
your
you need to direct
client-
all your questions to
Sorry.
Chair, please.
I would suggest then, very strongly, that, that the person that's involved with this issue go ahead and contract a survey company to come in and do the survey, so that you have the proper documentation to make the decisions that you need to make based upon that.
I mean,
And I
may
think
very
that would
well
be
require that.
probably a smart thing to do, and probably highly suggested, because, you know, I mean, you know, one survey company could come back and, you know, maybe, could be inches, could be feet, you don't know, you know. I did believe that I chose a reputable survey company to be able to do that. And, you know, if I was in that situation, I personally would probably go ahead and have my own survey done. But that's not my decision. So that's my, that's
That may
my,
come up at another meeting, that would be a requirement of,
I have no idea. So,
Well, I
I'm
just
gonna
want to
sit
be
down.
clear, as soon as that plan gets shown, it's a public record, and we get a copy of it.
Okay.
So if he doesn't want us to get a copy, he can't present it. I just want to be
Okay,
clear
that's
about
fine.
that.
That's fine.
That's okay.
Larry, are there any building permits on file for these buildings that are in question?
No, no permits on file for any other buildings. There are also, excuse me, the assessor's map shows no accessory structures.
Mike?
I think it's up to the applicant to get us a certified plot plan showing where this is, so then we can make a determination as to who's responsible for getting rid of the shed. If the shed's in his yard, then it's clearly his property, I would think. And then it would be his responsibility.
Okay. Well, we can certainly recommend that to the applicant now, so.
Well, you know, this is kind of a chicken and egg question. You got to understand, this is an appeal. It's the building inspector who's alleging that there's a violation. So if you're looking at it from that point of view, I think we can ask the building inspector on what does he base his determination. Because he's the one who says we're in violation. I don't know what he's basing that on.
Larry, you want to address that?
Sure, I've been on Mr. Pollard's property and saw the stakes that were supplied by Andrews Engineering. They clearly are the one shed garage clearly intersects Pollard's property. The other buildings on the property, the other garage has not been permitted, so again, that's a violation of the zoning bylaws.
So, I have a
So he's
question.
making it-
How many buildings are there, Larry, that are in question?
Well, there's two garages, and I don't really count the, there's a tent thing too, but,
Yeah, temporary structure,
yeah.
yeah.
There's also kind of a dog run or something, but that's so small too that somebody could pick it up and move it if they wanted to.
Mike?
I went on the GIS just before the meeting, and I printed out the property.
You had it when you,
Yeah, I know, but I printed out myself.
okay.
What is it, Jeff?
Where are the buildings?
Two houses.
Is it one of these two?
No, those are
Two
two
houses.
houses.
Two houses.
So it doesn't even show them on the assessment then?
assessors wouldn't know if building permits were never.
Well, I'm just,
Well, actually, we have the assessors records from back from 1980 that show these structures, one of the structures already, the assessors have them on their records.
So these two houses here?
So I'm comfortable that the building inspector made this decision based on a professional surveyor's markings.
Well, as I say,
I think the easiest way to clarify it is to get us a plot plan showing where these structures are, and then we go from there. If we can't go on the property, and we can't,
Yep.
so we don't have a map.
What were you contemplating doing between now and, I guess you wanted to continue it?
well, the first thing I'd like to do is get a copy of the survey, okay? I mean, we knew the survey was done, we asked for a copy of it, we haven't received it. I wasn't officially told I wasn't gonna get a copy. But we'll bring in the copy, so we'll actually know where the structures are in relationship to the lot line. And the second thing we were looking for is we found some records, as I say, we found the assessor's records back to 1980 showing that the structure was already there. We're still looking for documentation on the other structures, because if you've read the application, you understand that zoning violations have a statute of limitations, which is at most 10 years. 6 years if there's a building permit, 10 years if there isn't. This building has been here for 38 years, so we know that's well beyond the statute of limitations, and we'll be asking you to overturn the building inspector's decision because you don't have any enforcement power after 10 years.
That's one building.
The second one, we're still researching, we haven't found all the records, so,
Okay.
you know, until we have a good survey and we have all our records, we're just sort of talking.
Okay. Well,
Excuse me, but, Mr. Lane, isn't
Yeah.
it so that if you build a building, if it's 100 years and you build it on the wrong lot, the person that owns that lot, okay, owns that building? I mean, that law you're saying, that 5 and 10 year theory, I mean, that's great in the court. I've used that on you. And I'm gonna tell you.
Has it gotten you anywhere?
Yeah, of course I have. And let me tell you something, you know, it's amazing. The guy still owns the property. And he finds out that, hey, these two buildings are on my property.
Got a
Doesn't
bonus.
matter about how many years. He's a good dog. See how he switches it around?
Actually, see, you're getting beyond yourself. The question of who owns the proproperty.
I think we need to
I
stay
would think
focused
we
on
would
this
move
case.
to continue this
Yeah, I
hearing
think we
until
need
the
a plot plan showing where these structures are.
I do too, and
I'm not sure if it's
The-
fair that the abutter has to pay for that.
I'm comfortable with the building inspector's decision to go by a professional engineer, a surveyor that did it.
Yeah.
And I think the burden is on you to prove otherwise.
Mhm. There you go.
Well, as I say, we hope that we can produce the evidence that we need, and we're asking you.
Through a stamped plan.
Okay. I think, actually, Sean already made a motion, and I seconded it.
Yeah, there was one, Mr. Dudley, you wanted to speak earlier, do you still?
It was more of a personal nature, but I did want to mention, Attorney Lane's already mentioned that the structure, the structure that is of Patrick's objection, the building was purchased by my mother in the late 70s from Bill Carter for my father, for present, and there was no knowledge of exactly where the property line was. No one intentionally tried to put it, as Patrick said, on somebody else's land. I think that was rather demeaning, that comment that he made, of my father. And I take affront to that.
Well, if you can get us a certified plot plan showing that it's not on his property, we'll go from there.
Never mind.
So, why don't we continue this?
Yeah, I appreciate that.
We have a motion by Mr. Holland,
Second.
seconded by Mrs. Holmes, to continue this hearing until September 12th at 7:45.
Thank you.
Okay, thank you.
Excuse
Oh,
me.
all in favor?
Aye.
Aye.
Excuse me, you know, down with my... In this one. In this one.
The next,
Oh, yeah, I was just trying to include you. And your doctor said you have to
all right,
exercise.
let's go on to the next case.
Hey, Henry, come on.
Sam, ladies, if you'd like to talk, you're welcome to do so in the hallway. We'll move on to the other case. Okay?
Thank you for your time.
You're welcome.
Thank you.
See you next month. Okay, the next case is case number 2018-15, which is the continued public hearing for Dan Dudley, 160 Wallis Street. Applicant, counsel available?
Let's see, what's the spin on this one?
The floor is yours, Mr. Lane.
Thank you, Mr. Chairman, board members. That we were here last, I think you requested that we provide a plan, and we did provide a plan. We provided Mr. Pollard's plan, and it is right there.
This up here?
Please.
There you go.
And as you can see, we do have several buildings that appear to be on, or very close to the lot line,
Yes, we
and
do.
in fact do not meet the setback requirements in the zoning bylaws. But as we suggested as well last month, at least one of those sheds, which is the one, I guess, on the left,
This shed right
The
here?
one totally over?
that one, yeah, the one you were pointing at.
Yes.
Totally over, yeah, that shed. According to the records we have, has been there since at least 1987. We have a plan also done by Andrews Survey. Unfortunately, I only have one copy.
Okay.
And I'd be happy to pass around. You'll see that the 1987 plan shows the shed.
Right on the line, that shed right there, right?
Correct.
Over. There's one right over.
Yeah, over.
Yeah, the one over, it's been over the line since 1987.
Okay.
1980s, right there.
And there are ones that,
Was there a record of any building permit taken out for that shed?
no, there isn't. As far as, let's put it this way, the town cannot find one.
How about the applicant?
Applicant didn't build it. It was
It
built
doesn't
by-
matter, 87.
Built by his predecessor.
Nothing happened before 87,
No,
really.
the law says you don't need it.
Right, then, and that's the point.
Oh, no, Henry, come on, we can spin that on here. Come on, Henry,
What's that?
we can spin that one.
No, as we mentioned, and as Mr. Tassino is well aware, the statute says that if you have a building permit, you can, enforcement authority ends after 6 years, and if you don't have a building permit, your enforcement authority ends in 10 years. We have over 30 years, so our position, at least with regard to that shed, is that there is no authority within the town to require us to remove that shed, which isn't to say that Mr. Pollard may not have any recourse, but at least with respect to the town, we are now grandfathered with respect to that shed. We can't make the same case for the other sheds, and you will have to do what you need to do with respect to those. But at least with regard to the one that's over the line, that there is no enforcement authority with respect to that. So we would ask that whatever decision you make with respect to the other structures, you make it clear that you are not requiring us to remove that shed.
Mike?
Is this 160?
Yes,
Okay, so this is the neighbor's
that's
shed.
Mr. Pollard's, or the Pollard's property, right?
Point of order. Mr. and Mrs. Pollard, please.
I'm sorry?
Mr. and Mrs. Pollard, please.
I did correct myself.
Thank you.
Thank you.
All right.
Excuse me.
Oh.
Excuse me. Okay. Now, you're talking about the shed that's on the line, right?
I'm not talking about the shed that's over the line.
Yeah, over the line, okay. Now, and it's been there more than 10 years,
Yep,
right? And it's on their property?
that's
Oh,
correct.
The neighbor's
Okay.
property.
No, whose property is it?
It's in the neighbor's. This is his, it's in the neighbor's yard.
Wait a minute.
That's what I just asked. This is 160. This is the neighbor's property, that's where the shed is.
That's where the shed is. I thought there was a house over there. That's just a shed we're fighting over here?
There's two houses now.
There's two houses.
One right there and there's one over here. One over here, I'm sorry, to the right.
Okay.
Yep.
So the two houses that are on the wrong lot.
No, they're on the right lot.
The shed is
The
on the
shed's
wrong
on the
lot.
wrong
Oh, the
one.
shed's on the wrong lot.
Yes.
Okay, but it's right on the line.
It's actually over the line,
Oh, but it's been here 10 years.
been there 30 years.
Yeah, 30 years. Yeah. Well, it's very easy now.
Sorry, I apologize, I didn't miss it.
Mike?
It's a house.
Isn't this the neighbor's shed?
Yes.
So they should be applying for it.
Applying for,
Well, they're encroaching the setback.
This woman desperately wishes this.
I understand.
If the shed's in their yard, isn't it their shed?
I don't know. I'm not an
Well,
attorney.
I'm a little confused. You just.
Possession is 9/10 of the law.
Well,
Sure, piracy works that way.
I'm just, the applicant provided us with a plot plan that shows the property line, and it has a shed in the neighbor's yard. I don't understand what.
Well, I have no problem if the building inspectors want to stipulate that the enforcement order is not intended to be addressed to us, then that's fine. We withdraw our request with regard to that structure. But I don't want to, I don't make that presumption. I mean, the building inspector is here if he wants to make it clear that enforcement order does not relate to that shed, because it's the Pollard shed, then, we'll deal with that.
Can I be so bold as to ask what is that shed being used for?
I think it's just for storage.
Oh, okay.
Nobody lives in it, if that's
Mike?
what
Looks
you
like,
The enforcement order, is that on one shed or three sheds, or?
It doesn't really specify, it just says,
Could I
I
ask
think it
Larry?
said multiple,
it
didn't
says
it?
multiple accessory buildings.
Could we hear from the building inspector?
So, I don't know how Mrs. Pollard feels about using that plot plan to show anything, because Mr. Douglas didn't pay for that. So I don't know if that should be even present. So there's a house here, there's another house with a garage under that was been permitted on this lot. So this plot plan supplied by Dan Dudley is not reflective
Current.
of what's there,
it's not current.
not current. So even if it's a shed on somebody else's land, I don't know why this plot plan is valid at all, regardless of the date. Okay, since it's totally on the neighbor's property. The issue I had basically was this, this.
Right.
So there's a little house here that's the original house. There's another garage with an apartment above it. Over here that was permitted 10 years ago. This garage shed, or whatever you want to call it, is unpermitted and not within the setback. There's another one here,
Another one what?
another garage on this property, unpermitted. If you look at the setbacks, excuse me, it's not listed here, for that zone, I think it's 50 in the front, 25 in the back. This whole lot is basically 80 feet, 85 feet. So if any buildings on this lot over 10 foot wide, it should have been
Yeah.
come for variance, come for zoning. So, that's kind of where your decision lays. The other point I have to make is, since they're looking for relief, it's, burden of proof is on them for the age of this and this other
Right.
building.
Okay, thank you, Larry.
The question Mr. Lynch did not answer is whether he is expecting that enforcement order to address that shed that's over the line.
Well, is it, maybe that shed belongs to the neighbor, I guess.
Well, it's a very simple question. He's issued an enforcement order, okay? And the question is did he intend that enforcement order to apply to that shed? If he did not, and we are not being asked to remove that shed, that's fine. If he is asking us to remove the shed, then that's an issue. But we have to know from Mr. Lynch whether he intended that enforcement order to apply to that shed.
I have a simple question.
Yes.
Why doesn't your client just move the sheds onto his property and make this all go away?
If it was that easy, we probably would have done that. But as Mr. Lynch has indicated, we have some real constraints with regard to the size of the lot.
Why don't you apply for a variance to put them on your property and less than this
That
required
may well be the
setbacks?
next step, once we sort out what we're being required to do.
It seems like, I'd
It appears that an enforcement order should be issued to both parties, where there's a shed on the line over here. Right here, that's in this one, so the neighbor's encroaching on the setbacks. And then there's multiple buildings as well that Larry just mentioned throughout the property. So it looks like a second enforcement order should be issued to the Mr. and Mrs. Pollard.
She's
To
been
give
raising
them
her
that
hand.
Yes, go ahead, ma'am.
Diane Pollard, 6 Shady Lane. I'm a middle school teacher, so I might need some clarification here. So, Mr. Chairman, could you please just for a point of, and I don't know all of the individuals in the room, but are you from the Andrews Survey Company that surveyed our home?
Yep.
Did you contact myself or my husband to use our survey for this purpose? Did you contact us to ask our permission?
No, I was not. I was subpoenaed to appear and bring my records.
Were we given any kind of notification that this gentleman was subpoenaed and that our property that we paid over $5,000 for this survey, that we had expressly said at our last meeting that we did not want to be used? That were we notified in any way to be given our permission to be doing this? Not that I want to accuse Mr. Lane of doing anything underhanded. I just would like some clarification on what just happened.
Okay, well, we're here they're appealing the building inspector's decision. So I think that's an issue between you and the neighbor, or you and the neighbor's attorney.
Understood, but I think that I should have been given, as the homeowner and the owner of that property over there, that I should have been asked before that made it up onto the easel, if that was okay with me to have that up there. And it just seemed to go by very quickly, as if perhaps I wouldn't notice. But when I heard that it was Mr. Pollard's and mine, that was our plan, my first assumption, to assume best intentions, was that an additional one was created, that Andrews was hired to do an additional one, not that our property that we paid our survey, that is our survey.
understand.
I don't understand the difference between doing it this way or coming in my front door and taking our survey off my dining room table and bringing it over to that
I
easel.
understand, but that really doesn't have anything to do with this board. I'm not saying that you haven't been wrong. All I'm saying is
So my second question is, if I may, Mr. Chairman, is that in addition to the shed, which I would like to just clarify something here as well, that in our initial dealings with Mr. Dudley, we were more than happy to either purchase the shed from Mr. Dudley or help him dismantle it and move it over to his property. We were told that this shed had a great deal of sentimental value in his family and that he had no intention of moving it. And that is why we have not been, that's why it has snowballed to this degree. So I agree that this probably could have been rectified very early in the process. The third thing I'd like to bring up is, in addition to the shed, I feel that there's something a little bit more important, and that is the location of Mr. Dudley's well. We have not been able to determine that, and there could be a possibility that the well is also on our property unbeknownst to us.
you have to take that up with the Board of Health, but,
We have.
okay. Mike?
Just a question, is during the survey, did you ask the survey company to locate a well on your property?
At the time, we located our well on our property, but it never occurred to us at the time that there would be an additional
Not
well
that
that
they would
was
be
there.
easy to see,
Right.
but
No,
I'm just.
no, we
just
weren't
curious.
aware
Yep.
until after that there was a possibility the well was also on our property.
Excuse me,
Lou?
who was your engineer?
The person who did the survey?
Yeah.
I believe the gentleman who's representing this company, Andrews?
So you did the survey for her,
That's correct.
then you
Yes.
came back and did a survey for him?
No,
No.
No,
Oh,
no, he took our survey, money was exchanged. No, money did not exchange hands, and that is our survey that we paid for that is being used as a piece of evidence here without our permission.
see, I always looked at it, and I know that Henry will agree with me, but God knows if he will or not. If it's on that property, whoever property that shed's on, that's who owns the shed. Am I right, Henry?
I won't,
He won't say nothing,
I won't
but
say
it is. If you, property's on your property, shed's on your property, you.
Mike?
To the point of getting back to what we're doing, I think if we had asked for a certified plot plan from Mr. Lane at the last meeting,
Right.
and we still don't have one. It shows the neighbors, but it doesn't show what's on his property. And
Right,
as the building commissioner pointed out on this one, I don't even know what the date is on it, I could look at it. It doesn't show all the structures in there. So, again, I still think we need a certified plot plan from someone showing what all the structures are, so we can identify those structures. And I still maintain that this other one that's shown in the neighbor's yard, that maybe Mr. Lynch should be issuing a enforcement order on that one as well.
Well, the abutter has a shed on their property that they didn't know they had. So for them to be fined, I don't find that particularly fair.
I would say it's your shed, wouldn't you?
I'm not an attorney, but I would.
I'm sorry.
Lou, I can't fathom this. I can't understand why an abutter couldn't use some common sense, make this go away, move the two sheds onto his property, and end it. I mean, that's what normal
Yeah.
situation would happen, but it's beyond me. I just don't understand. I truly don't. There's no need for this hearing, there's no need for it. All people have to do is be respectful of other people's property, and if it was an honest mistake, move it. If it was an intentional mistake, move it. I mean, I don't know, but I would be in favor of Mr. Lynch fining him $300 a day for every day that shed is out of zoning setback conformance.
I would just give her the shed. How's that?
This is just,
Yeah.
this is,
if it was as easy as simply moving the shed,
knock it down,
you probably would have.
rebuild it.
But
It's simple.
You heard-
Henry, it's done every day of the
you heard
year.
Mr. Lynch tell you what the constraints of the site are.
Then destroy it.
And that,
I mean, it's on somebody else's property. Don't people have rights? They're paying taxes for their own land, and there's a shed on their land. It doesn't belong to them.
I agree completely. I'm
So-
not disagreeing with you.
Why it ever got to this room is beyond me. Ma'am?
I just would like to add just one more thing too, is that it's an insurance risk. Because if someone from Mr. Dudley's family were using the shed and should get hurt moving a piece of equipment on our property, then we would be liable because suddenly the shed would indeed be ours. And that is not something that we want to take on.
Okay, thank you.
And as a teacher, I'm really disappointed in you. You should know better. And both of you
You
should.
didn't have any choice, I'm
Not,
afraid.
well, then that was not
Okay.
okay.
Mike?
Again, I need a certified plot plan to understand the constraints of this
Why
lot.
don't you just give her the shed?
Doesn't matter what the constraints are. I mean,
Oh, I know that.
there's a zoning violation. So,
Go back
And there's
and forth.
And
multiple
they're-
zoning
they're-
violations.
there's multiple ones, and they're appealing Larry's decision that says they have a zoning violation.
Yeah. it
So they
doesn't
haven't proven that they don't have one. Matter of fact, they've acknowledged they have one.
Refresh my memory, why are we here?
Because
To
they're
give 'em relief
appealing.
on- To give them relief on
No,
these sheds?
no. They're appealing the building commissioner's decision.
Right,
Okay, so we can vote on that.
okay.
Right.
That's what we should vote on.
Right, and I think, well, I'd like to give them some guidance to, in terms, I mean, we just voted a few months ago to fine people, and money talks. Gets people to,
I think that.
Can I ask you, so, I apologize, the top property is whose property?
this is Mr. Dudley's property from here to here, and this is the abutters property.
And the abutter is the owner of the shed.
Mr. Dudley
We did
built
not purchase the shed.
these two sheds. He built these two sheds.
Which property, I apologize, which the bottom property is Mr. Dudley?
Yeah.
Correct.
And the top property is who? I can't read it, I cannot read it from my
Pollard's.
glasses. Pollard's, all right. There was an enforcement letter to remove from the Dudley property, the shed?
Larry, do you have a copy of that enforcement letter?
Yes, I do. We do have, for Mr. Dudley, GIS map that shows the two buildings on his property.
Wait a minute, you're saying two buildings on whose property?
This
Mr.
is
Dudley's
Mr.
right
Dudley's.
Okay.
This is the original building, and then they put a garage with a living unit above it.
So where's the
That's
shed?
where
It's not on that.
you can see approximately, the little tiny shed is there. There's a garage type of thing here.
It's not a certified plot
And
plan,
then
Larry.
there's another, I know it's not, but
You can make
there's
a
another, but even that shows the width of the property. That's 85 feet tops.
There you go.
Well, I guess what I'm suggesting is that I don't know that if it's been open and notorious control, that the ownership interest is so obvious. But, for instance, why wouldn't they have it by adverse possession? Having had access to it, having had the property on there?
That's an issue that obviously is the elephant in the room. We've had it there for over 35 years. I suspect if it's ever adjudicated, it's going to be determined that we own it by adverse possession, but we haven't got that, determination yet. We haven't got to that point. We probably will at some point, but, we're
Is
not
it
there
worth
yet.
it?
What's
Is
that?
is that thing worth paying you, pardon me?
I'm cheap.
I know, really.
Apparently.
To let that stay there on somebody else's property. It doesn't make sense.
I'm not disagreeing with you, but that's not my
You think
decision.
it doesn't make sense
It's
either?
not my decision either. I agree completely that neighbors acting in good faith should be
Yeah.
able to resolve this one way or another. But obviously, since we're here, that's clear that neighbors have not been able to resolve this amongst
Excuse me,
themselves.
please. I hired a fence guy, and he put a fence on a piece of property. And when the guy did his survey, he found out the property was on his
The fence is
property.
on this property, yeah.
And the guy, his lawyer called me up and he wanted to say, well, you gotta, I said, no. You tell your man
He
he
owns the
owns the
fence.
fence. It's on his property.
I was-
That's it. I mean, that's easy mathematics, right?
Right.
I was lucky enough to,
Thank you, Larry.
that I knocked on the door, Pollard's, and I was lucky enough to go down the property line and take some photos if anyone wants to see them. What stuck out the most, in my opinion, is when you put these survey sticks in the ground, sometimes they last for 3 or 4 years, maybe even longer. So I found Andrew's surveys, of course, with all the orange tape on them, whatever. But I did find some older ones that have probably been there for numerous years. So
Whose property were they on?
this is the property line between the two.
Oh.
So they were lined up exactly where they were before. So I guess what I'm saying is whoever did the survey before, whether that other building that's been pushed back, that's viewed here on this picture, is, I'd like to see it go ahead. Obviously, he knew he was on someone else's property. Actually, it's been said by a building commissioner that we weren't supposed to talk to the wife because she admits that they knowingly built the shed on this guy's property, or built that garage, whatever that is. So,
And we know about that, too.
yeah, anyway.
So we ready to move
No
forward?
garage there.
So the case is, they're appealing the building commissioner's decision to have them get into compliance.
Well, as I said earlier, I understand what you have to do, and my only question is, can you specify if the order relates to that building that's on the Pollard's property. Because, as I say,
Can I see the two letters? He gave you the two
the
letters.
question is whether it, whether it violates a setback requirement, and that doesn't really matter who owns the building. It clearly violates the setback. If the Pollards own it, it violates the setback. If Mr. Dudley owns it, it violates the setback.
That's not why we're here tonight.
But the key is, regardless of who owns it, it's been there for more than 10 years, and therefore the town
Where's
is...
common sense, Henry? Come on.
Yeah.
Yeah,
Is there any
but-
common sense in this?
Well, I understand that, but we need to have a decision on that issue, okay? And as I say, it doesn't, well, I'd say it doesn't matter, but we need to know whether the enforcement order, and I suspect that, in all likelihood, the board is going to uphold the enforcement order, we need to know whether it applies to that shed. Because we take the position that regardless of who owns it, it's beyond this enforcement period, and the board has no authority to order that shed removed without respect to who owns it. You can't order the Pollards to remove it, you can't order Dudley to remove it because it's beyond the 10 years. It's a simple proposition.
That same thing
Why
goes
would
in
you,
my
why would you
house.
want the neighbors to have the liability that's undue to them? They didn't do anything to incur this liability.
We can have that discussion sometime, but that's not this board's decision. This board's decision is, was that shed put within the setback within the last 10 years, regardless of who put it up? And the answer to that question clearly is no, and therefore, we're simply asking, if you issue an enforcement order, an affirmation of the building commissioner's enforcement order, you make it clear that that order does not apply to that structure because that's beyond the statute of limitations. The simple proposition.
You're talking about...
That's
Mr.
nitpicking.
One second. Larry,
Craziness.
You're talking
one
about
minute,
the one-
John. Larry?
I would have to assume that if it's on the Pollard's property, I would have to issue them a order to remove it. I'm talking about the other two buildings that are either over the line or
Because you said
not in
sheds.
compliance, the larger two buildings.
Okay, so you're talking about Dudley, the Dudley property,
Dudley,
Yeah.
period.
okay?
Okay.
So,
And
That's easy.
he does say in here sheds. So,
Yeah,
More than
it just
one.
doesn't identify which sheds, it just says sheds.
they don't have.
Was
He only,
multiple.
he only identified one piece of property. And from what they presented, as well as what's up on that board, there's a shed on the adjoining piece of property, and that's why I had suggested at the beginning that Mr. and Mrs. Pollard also be issued an enforcement order, and I don't think that triggers a fine. Have you fined the Dudleys as of this point?
Yeah.
So, this has been going on for a month, so if they didn't agree with it, they would go through the same process as the Dudleys and appeal the decision to keep their shed.
Or not, or tear
Or
it down.
whatever, that's totally up to them,
Yeah.
but the way, the stuff that, the plot plans that's being submitted to us, the one that he submitted, and that the Dudleys submitted, showing the neighbor's shed, but doesn't show their own. All right, so if we have to make a decision on that shed, is what Mr. Lane's asking about, I guess then, to be fair, we would have to issue a enforcement order to the
Yeah, Larry
neighbor's
Bird.
property, because they're encroaching into the setback as well.
That would be different, I mean, that would be later on, because
Yeah.
what we have to address tonight is what happens tonight.
Right.
Oh, yeah.
That's
If
up
the
to-
building
no, that's
commission
up to the
wants-
I
building
understand that,
If
but
he wants to do, I understand,
Mr. Lane's asking
which shed?
for us to make a decision on that shed.
Sheds.
That's not what we're here for. We're
No.
here for Mr. Dudley's property.
That's right.
And I haven't been on his property. I don't have a plot plan like I asked for, so I can only assume there's multiple sheds on there. So if the decision, so he wants a decision on those multiple sheds that are on this property, I would assume.
That's all
Then
I'm
that's the
asking.
decision that we should be voting on tonight.
Okay, or
if-
do we want to go back to your original suggestion to have Mr. Dudley have a certified plot plan so that we can see where all the buildings are, so that we can go, okay, the building commissioner's
We asked
decision.
them that, we afforded them another month in order to
Yeah.
provide that, and they chose not to provide it. So, based on the evidence that we have and the information that we got from our building commissioner, I feel
I
comfortable
believe
making
last
a
month,
decision.
Mr. Lane, you said that you were in disagreement with the Andrews plan. I think those were exactly your words. You disputed it. disputed the Andrews plan.
I don't think the plan was presented.
No.
No, it wasn't.
We weren't allowed to see it. Mr. Pollard was here, and he had the plan, and he said he wouldn't unroll it if I laid eyes on it. So I said, okay, doesn't come into evidence, and it didn't. So we subpoenaed it for tonight.
So Larry, you're looking to enforce the sheds that are on the Dudley property? Right.
Yes.
So that enforcement, if there's sheds that are on a butter's property, that was not your intent in that enforcement. Your intent was to have them comply with the sheds that are on their property.
Great, thanks, that's just a clarification I was requesting, so
Took us a while, but we got there.
we got there.
All right,
So how's the motion gonna, because you need to be in favor, so how's this work?
they are appealing. He is appealing the building commissioner's enforcement order dated June 1st and June 15th.
So, the motion should be made to overrule the enforcement order issued by the building
Well,
commissioner?
No.
Advice.
Overrule?
You wanna go the
Ah,
other way?
what it is. I'm asking you.
The-
I didn't say it.
The motion should be to
Uphold.
approve or uphold
Uphold.
Mr. Dudley's appeal
Okay,
of the building commissioner's enforcement order dated June 1st and June 15th.
so moved.
Make it with respect to the buildings on his property.
It's,
I
that's
think
what it
that's-
says. That's what these
It
say.
says on property located at 160 Wallis
Right.
Road,
So
at
that's
Mr.
it.
Dudley's property.
As long as we're clear that does not include the Pollard's property.
So Mike made a motion
Second.
to approve the appeal of the building commissioner's enforcement order dated June 1st and June 15th, 2018, pursuant to Chapter 48, Section 7, on property located at 160 West Street, Assessors Map 158, Parcel 19. Does that clarify everything? Okay. We have a second?
I did.
We have a motion by Mr. Fitzpatrick, a second by Mrs. Holmes. All in favor?
Aye.
Opposed?
Aye.
Oh, I had it backwards, Mr. Clerk. I apologize.
Okay.
I would like to retake my,
retract
take
that?
my point. I apologize.
So it's unanimous.
It's unanimous.
All right, so the decision unanimous to uphold the building commissioner's
Yeah. Order.
enforcement order for property at 160 Wallace Road. Okay.
Thank you for your consideration, it's always a pleasure.
Thank you.
I didn't vote, see that? I was on my side. Henry, why don't
Public hearing and ask for
Yeah,
Put it in this front yard.
we didn't close the public.
They don't have any rooms.
No, they will.
You know what, we didn't close the public hearing, so let's do that, and we'll do it all over again.
Hey,
Okay?
Henry, we gotta do it over again. We didn't close the public hearing.
Oh, I get a second bite at the apple?
Yeah.
Do you have any new information, Council?
Make a motion to close the public hearing.
All right, we have a motion by Mr. Bombara, close the public hearing. We have a second,
Second.
seconded by Mr.
201813.
Fitzpatrick. All in favor?
Aye.
The public hearing is closed.
Can you read my motion again, Mr.
Yes.
Chairman?
We have a motion by Mr. Fitzpatrick to uphold the appeal
Oh,
of the building commissioner's enforcement orders dated June 1st, 2018 and June 15th, 2018 pursuant to Chapter 40A, Section 7, on property located at 160 Wallace Road, Assessors Map 158, Parcel 19. That motion was made by Mr. Fitzpatrick, seconded by Mrs. Holmes. All in favor?
aye.
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 No.
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 Oh, God. we
Aye,
can't
it's
do
missing.
this.
No.
All right. All in favor? All in favor?
No.
Opposed?
Aye.
Aye.
There we go.
Unanimously opposed.
Thank you.
Who's next? Is you okay? Are you happy with
Let me
everything?
see if we gotta move again.
No, no,
Oh,
no.
yeah, you gotta leave again.
I'm all right, thank
Good
you.
far too long.
It
You gotta
has
leave
nothing
again.
to do with the shed.
feel towards you.
Far beyond that.
Yes, it is.
Yes.
So,
Do you want to step out?
Yeah, I think that
that's a good idea.
Okay. Oh, it's 9:08.
We gotta get out of here.
Okay, next case
You
is...
can leave now anyway, because you gotta leave.
Yeah, you can leave.
You can't sit here for this one, this is Roslyn Road.
Is that you?
You own the terrace. You can't even vote on the mailbox at the top.
Mike.
Reed Road.
Who's gonna fix my road?
Am I near you?
You're near everybody, you own all the roads, remember? You bought the whole community. That's what you said earlier.
My own virtual.
Okay.
Right.
But on my side too, so tell me
Louis,
what
are you
want me to say.
excusing yourself?
Yes, I'm
Okay,
excused.
thank you. Okay, next case is case number 2018-14, a public hearing of Eugene Gilman III, 1 and 3 Reed Road. Date of the application was August 22nd.
Okay.
They're applying for a variance. It was posted in the town hall as well as advertised in the Worcester Telegram and Gazette, and it read as follows. The Town of Douglas Zoning Board of Appeals will hold a public hearing at 8 p.m. for Eugene L. Gilman III. He is requesting a variance in a rural agricultural zone district pursuant to the Douglas zoning bylaws to allow the construction of an accessory garage on an undersized but grandfathered lot with less than the prescribed front, side, and rear setbacks on property located at 1 and 3 Reed Road, Assessors Map 284, parcels 205 and 206. Certified mails came back, Maria? Yes. Okay. Great. The public hearing is now open. The applicant and representative?
Oh, you're back.
You're back again?
We didn't miss you.
I recognize that tie anyway.
I gave him that tie for Christmas.
It's either University of Michigan, if you're from there, or if you have relatives in the Navy, it's also the Navy. I have relatives in the Navy.
Hey, Mr. Lane, the floor is yours.
Thank you, Mr. Chairman and the board members. This is, as you indicated, this is a request for a variance.
Good. Remember this one?
Variable names who are seated here. And as you can see from the application, they currently live at 1 Reed Road, corner of Birch Hill Road, Reed Road. And they would like to add a garage to their property. The lot's 15,000, almost 16,000 square feet, and it's a combination of the property 1 and 3 Reed Road. So the house was originally at 1, and they subsequently purchased the vacant lot behind them, which is 3 Reed Road. So they're now combined into a 16,000 square foot area. So it's a grandfathered situation, so the building is grandfathered, obviously, it's been there for years. And as I said, we're just now adding an accessory building.
I apologize for the late notice, but I think I should step off on this one. Sorry about that.
No problem.
Really?
So,
How much
voting on,
faster things will go.
just to make it clear, voting on this case would be Mr. Fitzpatrick, Mrs. Holland, Mrs. Holmes, myself, and Mr. Bombara.
Messed me all up when you said Mrs. Holland. I'm like,
Go ahead, Attorney Lane.
One of the issues we have is that this is, as a combined situation, it's a corner lot. And unfortunately, the Douglas zoning bylaws are not as clear as they might be with respect to how you treat corner lots. So depending on whether the frontage is on Reed Road or Birch Hill Road, the rear lot setback changes. If it's, if the frontage is on Birch Hill Road, then the rear lot, and not on Reed Road, then we meet the rear lot setback. If it stays on Birch Hill Road, then we don't, we're 5 feet short, because they require 25, and we have 20. And a similar situation on the front lot setback. The requirement's 50 feet. If Birch Hill Road's the frontage, then we clearly meet it. If Reed Road is the front, then we're 24 feet short. So, again, depending on how you treat the corner lot, we either need several variances or only one.
What is the legal address of the property?
Yeah, it's Reed
Well,
Road.
it's 1 and 3 Reed Road. But
It's the front of the building is on Reed Road, it's not on Birch Hill.
No, but the lot has frontage on both. Corner lot.
Corner lot.
I guess we could
Technical.
quibble, but I think this,
I don't
that the
disagree.
state of Massachusetts probably has a definition for where the address is when,
Oh,
in-
yeah,
depending on the siting of the
I'm
house.
not disputing what the address is or what, I'm just saying that Douglas's bylaw does not specify how you treat corner lots. Different towns have, that specify that it's the longest frontage or the one that the house faces. There's all kinds of bylaw requirements with regard to how you address that. And the only question here is, I'm assuming the worst, and that's what we need the application for. But I'm saying there's some ambiguity because Douglas's bylaw doesn't specify how you determine which is front, which is rear. Or some towns say you have to meet it on both corners, And again, Douglas does not have that provision, so, I'm not saying there's anything wrong, I'm
So
just
you
saying
need
there's some ambiguity.
Are we in agreement the house
Reed Road?
the frontage is on Reed Road?
Correct. I am.
What's the address?
Okay.
Do you remember this from a year ago? Because I do.
I
It's
think
like-
Henry was just trying to help us identify some weakholes in our zoning bylaw.
Yeah, just, you made them aware though.
Okay.
So, assuming that we agree that Reed Road is the frontage,
We do.
then.
We do.
Then we meet the rear lot requirement, and we only need a variance for the side lot and the frontage, and the front lot setback, because we don't meet those.
Yeah.
Because we have 36 in the rear, we only need 25, so we comply there.
But you don't comply with the front.
We don't comply with the front
On
or
the
the
side.
side, we're 5 feet short on the side, and
Right.
24 feet short on
Mhm.
on the front lot setback. So that's they say we're fine with that. I mean, we can't make it fit.
Understand.
Basically the situation.
Hmm.
But, as I say, this lot's 3 times, almost more than 3 times the size of many of the abutting lots.
Yeah.
We can comfortably put the garage in there. It's obviously an accessory use which is permitted. Grandfathered situation. Years ago, we didn't even consider this to need a variance, but under the current regime, I guess technically this does require a variance. Very similar to the one you gave last month to, I can't remember who it was.
Oh, because there's a double lot, right,
Right?
yeah. Because I remember this one was
Actually, it's a triple lot.
triple. Yeah.
Tell me about the pond in the front that's shown on this drawing. Man-made drainage pond?
That's something I just created with my own.
You know what, sir, you just can't speak out. You have
Oh, I'm
to
sorry.
be, name and address, because the minute taker needs to know who's speaking.
My name is Eugene Gilman, I own the property.
Okay, thank
There
you.
was some runoff from another lot coming down the hill and kept on running down the road, so I created that just to keep the water in check, so it wouldn't wash out the road until I put something there. So it's not an existing pond, it's something I created.
Just a swale.
Hmm.
You do have some drainage problems. I was up there before the construction on the road on Wallen Lake took place. And there's not much left of Reed Road.
No, it's been like that for years.
That was all gravel up there.
Yeah.
Oh, yeah, that's right.
It's gravel right back into the lake.
Okay,
Louis Road.
Sorry.
Anyway.
I couldn't resist.
That's right, we gotta fix that.
So,
We'll speak to the owner of the road and see if we can get him to upgrade that.
Oh, don't start that
Good
again.
luck with that.
Yeah.
I'll hang on to these.
um,
I take no issue to Ms. Gilman's request.
I mean, just thinking, is there any reason you meet this rear setback? Is there any reason you couldn't move this back so that you could
Yep.
minimize the needed variance for the front?
I guess there's nothing we can do to make it comply. Could we shift it? Can we just shift it?
Well, if we shift it back, it puts it closer to the property line, and we're gonna have a hard time pulling into the garage doors, because the garage doors actually face the
They
house.
face the house. Yeah.
And that's why I was trying to kick it back that way, so we don't have to make the swing. I could push it back the other way, but then, like I said, we have 20 feet now, that's not enough now, so if I pushed it back, give us more room between the house and the garage to pull in, then you lose a setback to the back, so I just figured that's the best way to put it. And there's a big boulder to the right of my garage that the excavator couldn't even do anything with it. I mean, it's that big, so we have a hard time with that too, so I think that's the best way to deal with that.
So, Mr. Chairman, is this a three-car garage? Or
Yes, it
it's a
is. Yep.
huge?
3-car garage.
Yeah.
So, but you're proposing to be 18 feet from, 18.3 from the existing house. So
That's what
if
you
you did
drive
move
in.
it back, it appears you'd still be 18'3". And
Oh,
this,
no, I'm talking about as far as moving it back towards the
See,
Hurley's property. Give us more room to fill
this
in.
way.
Yeah.
20, he's going
But
backwards
he
the other way.
I think he wants to
Just
drive
talking
in
about
this
moving it
way.
right.
Exactly,
Yeah, to
yes.
the right, but that's
Wants
what
to
I'm
drive
saying.
straight
There's
facing
a
his
there's a
house.
rock in there. It's huge. It's a rock that's probably half the size of the garage in
Yeah, he's
this
got
area.
18, but he's got a jog in the house too. So
Yeah, what
what
he's
about
saying, Dan,
this?
is there's a large boulder right here in this corner,
Mhm.
and that's what's preventing him from sliding
Yep.
it over.
do board members have any questions for the applicant?
The large boulder.
Is there anybody in the room that would like to speak on this matter? Ma'am?
I'm Gail Drewley. I live at, I have a house at 4 Kearney Road. I'd like to speak in support of the application. Improvements to the neighborhood is always a good thing. Garages are in short supply in the neighborhood, and I support this.
Thank you. Anybody else like to be heard on this application?
Actually, Joe Gibbrey, 21 Birch Hill Road, a butter to Eugene and Sean for me. Gino and I spoke about it, because our lots abut, and because there was a change in the grade when they built the house. Gino had put in, and Cheryl had put in a retaining wall to hold back the change in grade, and it was just the stones that were there on the property. And our only concern was with the building of the garage, was it going to impact that retaining wall? And Gino and Cheryl assured me that they were going to actually improve that retaining wall with a mason. That was our only concern, because it was, our property was, over time, when our property was built, it was terraced on the terrace. It was, we actually have, I don't know if you, we have the glass front house if you ever drove down Birch Hill. So if you see that, there was a terrace up into Angel, and there's a terrace up at the part of Birch Hill,
Right.
and it was there. And so that's all our only concern, is that retaining wall that was there when the house was built doesn't get disturbed with that. Which they haven't.
Ma'am?
My name is Cheryl Gilmain. I also own the property. We haven't been able to do any improvements because we've been waiting to see if we get approved for the garage. So what we want to do on that whole area is design something really nice, but we're like at a hold right now because we don't know what we're going to do based on the garage. So we plan on fixing everything. Very nice.
We just
Yeah.
want, I said, we support the garage. It's just,
Yeah.
I was just in the building,
Believe
not.
me, I don't want that wall there.
Yeah.
So I'm so happy to see neighbors talking to neighbors.
So I agree.
How did you get a client like this?
You got lucky.
Friends, we were friends a while
We were
back.
friends before we knew Henry.
Okay. All right. Any board members have any other questions for the applicant or their counsel?
I'm happy to see some setbacks that are a little
More
Yeah,
than
well,
likely.
not
To
to-
reality?
Not
Yeah,
Yep.
yeah.
I agree.
6 inches off the line, like the other shed that we had to deal with a long time ago.
Mhm.
10-car garage.
Yeah.
Yeah.
Anyway,
So we do close the public hearing?
Yeah.
Make
Is there
a
anybody else that
motion.
wants to speak on this before we close the public hearing?
I'm Charlotte Gibbrey, we live right next door. We're all in favor of them putting up this garage. We
Okay.
really are.
You got a space in it, or what?
Well, my yard's
girl
way
sitting next
big
to her
enough,
said she
no,
needs a
but,
garage.
Yeah.
no.
There you go.
Okay, so I'll entertain a motion to close the public hearing.
So moved.
second.
Okay, we have a motion by Mr. Fitzpatrick, seconded by Mr. Bombara, to close the public hearing. All in favor?
Aye.
Aye. Board, want to make a decision tonight on this?
Yes.
Okay.
Go ahead, Dan.
What?
Go ahead, Dan.
No, you know, we've been asking people for plans. Do we have a plan?
We do.
We have a plan.
Okay.
Yeah.
Oh, sorry.
Yep, and then they brought in a plot plan too.
You had to
Yes,
look,
they
you had to
did.
look through your
Yes,
whole
they
folder,
did.
Pam.
It got stuck in the Tessino file, shall I say?
How come it's Louis, attack Louis night?
Okay. So,
Well, I'll move that we approve the request for a variance for the Gilmains, case number something or other.
2018.
2018-14.
I'll second it.
okay, and that be approved,
As
as submitted
indicated.
Submitted.
for 38 by 28 garage.
Yep, sorry, as corrected. Thank you for correcting.
On 1-3, Weed Road.
On the plan drawn up by
Karen Hanlon,
Gary and Hanlon on the, what date?
February 6, 2018.
Thank you. That's the one.
And built in accordance with the plan submitted, drawn by
SW Design Services.
SW Design for Gino and Cheryl Gilmain.
Okay, that makes it complete. Anybody want to, I'll amend my, my motion to include all of that. And who seconded?
I did.
I'll second it. John did.
We have a motion by Mrs. Holmes to approve the variance request for the Gilmains, seconded by Mr. Bombara. All in favor? Aye. Opposed? Thank you. Get the decision drafted and get it signed as soon as possible.
Thank you.
And Louis, you will fix the roads in the meantime?
I make a motion.
That road's okay.
For what?
Thank you.
Go ahead,
Thank you. This has been a long process. Thank you.
It hasn't been that long.
Yes, it has.
Well, on your end, but we've only just.
Appreciate it.
Yeah, we only saw you twice.
That's enough.
Okay.
You don't have to see me anymore.
But we'll miss you.
We're gonna come look at it after Louis fixes the road.
Yeah, I'm not going down there.
Yes.
I'd like to call to order the Douglas Zoning Board of Appeals meeting for Wednesday, January 9th at 7:15 PM. Our first item tonight is a public hearing for Dan Dudley, 160 Wallis Street.
Before you open the public hearing, I'd like to ask for continuance.
Okay. All right.
No, I'm not
Yeah, I
sure.
think we have to open it.
Open it, you can do it before, it doesn't matter.
Yeah, I think we'll open it.
I'd rather you didn't, but that's okay.
The,
They'd have to republish it, if that was the case. So,
So the first case is a public hearing for Dan Dudley. It was posted in the town hall and advertised in the Worcester Telegram and Gazette, and read as follows. The Town of Douglas Zoning Board of Appeals will hold a public hearing at 7:15 on Wednesday, January 9th, 2019, in the Douglas Municipal Center Community Meeting Room, 29 Depot Street, Douglas, Mass., to hear the application of Dan Dudley, who is requesting a variance in a rural agricultural RA zone district pursuant to the Douglas zoning bylaws, Appendix B, for a rear yard setback for a shed. The bylaw requires a rear yard setback of 25 feet, and the applicant proposes a rear yard setback of 4 feet on property located at 160 Wallis Street, Assessors Map 158, Parcel 19. Public hearing is now open.
Mr. Chairman, if I may, we'd like to request a continuance to your next meeting.
Okay.
I think the only immediate abutter is also here, and there's no objection.
Okay, that meeting's on February 13th. So, we'll do it at 7:15? Yes. And then we just need an extension on the decision date by 30 days, Henry.
Maria, you have that form?
Okay,
Oh, good, thank you. we need a motion to accept the continuance?
Yeah, we do.
Yes.
I'll move that we accept the continuance.
I'll second it.
Okay, we have a motion by Mr. Holland, seconded by Mr. Bombara, to continue the Dan Dudley public hearing till February 13th at 7:15 PM. And the applicant has also given us a 30-day extension of time to make a decision. All in favor?
Aye.
Aye. Opposed?
Thank you.
See you on the 13th. Next agenda item is case number 2019-01, public hearing continued for Dan Dudley.
Good evening, Mr. Chairman, members of the board. Shane Picard of Lane and Hamer in Whitensville, here on behalf of Mr. Dudley. For a request for a continuance.
Again.
There's some discussion going on with one of the neighbors, and based on that, we're asking it to be continued. Spoke to Maria, I think, earlier today, is that correct?
Yeah.
That's a good thing, we're just talking.
So, before we grant the continuance, we also need you to fill out something saying you give us another 30 days on the decision.
Sure.
I believe Maria has that form.
This is still over that little building?
Buildings. Yeah.
Yes.
Mr. Chairman, do you have that case number again?
Yes, it's a 2019-01.
You need to remember, right?
So we can have another 30 days, because this is 100 days from application. I mean, it's like a set.
It is, but this agreement says that we'll grant them a continuance on the condition that they extend the decision, extension of time to make a decision signed by the applicant.
Yeah, I know, that's the issue. That was going through my mind.
Picard, do you think we're gonna hear this next month? I mean, I don't know how many people are here to discuss the case, and I hate to have people keep coming in.
Yeah, I believe so. My understanding is that everything's lining up. I have not been primarily involved in it, but I know the facts. And I know the basis for the request for the variance, but, without going too far into the details, there's some, the parcel that, is currently encroaching on the neighbor's property. I'm sorry, not the parcel, the barn shed. We're trying to discuss those details with the neighbor. And so we received a call from the neighbor's attorney today, and actually they initiated a request for a continuance. So we're trying not to step on toes in that regard. I know it's inconvenient, but
Trying not to
Trying to
ruffle
work-
any more feathers?
trying to work a global settlement here.
All right, so we have a request from the applicant to, case number 2019-01 for continuance to 7:15 in our March meeting,
March 13th.
March 13th.
So moved.
Okay, so you...
I'll second it, but I do want to just say that with your with your discussion about possible abutters coming, makes it very difficult, and I think that Mr. Dudley ought to be put on notice that we need to move forward with this, so that the abutters can exercise their rights.
So noted.
Okay, yeah. The continuance is
I understand.
not a guarantee.
So I seconded.
Okay, so we have a motion to accept the request for continuance from Mr. Bombara, seconded by Mrs. Holmes. All in favor?
Aye.
Aye. Okay,
Thank you.
continue to March 13th at 7:15.
Take it easy.
Good night, thank you.
The next agenda item is the continued public hearing for Dan Dudley, 160 Wallis Street, case number 2019-01. It's a continuance of public hearing. Yeah.
Good evening, Mr. Chairman, members of the board. Shane Pickard of Lane and Hamer from Whitensville. Here on behalf of, thank you, here on behalf of the applicant Dan Dudley. Last month, you may recall, we requested a continuance to tell the board that, I may say,
Please.
I can tell the board that my client, Mr. Dudley, is here in the room, as well as the abutter, Patrick Pollard. This application involves some sheds, essentially, some outbuildings that were constructed on Mr. Dudley's property some years back, in some cases as many as 35 years or more ago. But unfortunately, some of those buildings are either encroaching or within the setback area. We filed the application for the variance essentially because Mr. Dudley's lot is very long and shallow. And given the essentially it's a 75-foot front setback and a 25-foot rear setback.
It's 50.
50?
Yeah. 50-foot front setback.
Oh, okay.
1525.
Yep, 1525.
That's right. And his lot is, as I said, it's very shallow, such that it's difficult to locate even a shed without being in the setback areas. For that reason, there were some other issues. I think I mentioned at the last hearing that there was a question about the location of a well. They've located the well. It is on Mr. Dudley's property, so there's no issue there. I can tell you that, somewhat unusual, but the two parties are here today and they're in agreement as to what they want to see happen. However, there is I guess you could call it a small hiccup based on, if I could just distribute this is what I've prepared here is an amended application. I'll talk about that in a moment, but what I'd like to draw your attention to first, the two documents stapled to the rear. These are plans prepared by Gurr and Helen. I could just hand those out. Read it on that side. Read it on that side.
Thank you, John.
If I could direct your attention to those two plans. The second one is just a larger version of the first one.
You have an extra copy of that?
Sure. Unfortunately, that's all I have. If I could direct the board's attention just to the upper left corner of this larger plan where it says proposed property line. And certainly, Mr. Pollard, I hope will correct me if I say anything that is not his understanding. The parties have essentially discussed that Mr. Pollard will convey a small portion of his parcel, measuring approximately 6 feet by 22 feet, to Mr. Dudley. What that would do is it would ensure that the shed, which is located to the northeast, would be entirely on Mr. Dudley's property. Does not relieve the issue of the setbacks, however. And that's where I said there's a little bit of a hiccup. So the complication there would be two things. I'll mention the first one, take them in order. By creating this sort of offset here for the shed, we have now not only a rear setback issue, but also potentially a side setback issue, depending on how you look at the lot in its new configuration. In other words, the 6-foot lines are now technically sidelines of the lot, and therefore we also have a 25 setback from those. So whereas our original application asked for only a variance with respect to the rear setback, technically now we'd be looking for a variance with respect to the rear and the side setbacks for that shed. Are there any questions about that issue? Okay. The second issue is, originally, we had not included the lower shed. This would be the shed to the southwest. You can see on the plan before you there. Lower down on the plan it says move shed. Where Mr. Dudley's shed is currently located entirely on Mr. Pollard's property. He would like to move it off of Mr. Pollard's property, which Mr. Pollard is in agreement with, my understanding. But again, given the nature of his lot, the fact that it's very long and very shallow, again, we're having difficulty getting it any place on the lot where it would not still be in violation of setback. So it's the same request, just with request of both of these sheds.
How big is that shed?
The dimensions of the second shed?
Yeah, the one you gotta move.
Mr. Duffy, do you know?
The exact measurement, no, but it's probably like 12 by 10 by 12, something like that.
Okay.
It's nothing like the size of the other one.
Does that answer your question?
Oh, no, because if it's 10 by 12, you don't need a setback.
I don't have, I'm sorry, sir, I don't have the exact measurement. It's something like that.
Yes, he did.
Right in line, Douglas. Put them right in the line.
Nope.
I would love it if that
Because
were.
I just need a building permit.
I know.
I have to get
You don't
one
need a
for
building
myself.
permit, but
You don't need a building permit.
You don't need a building permit, you have to comply with
But you
zoning.
can comply with zoning. The
Mark's
building
trying to
inspector's
get
here
your
right
attention,
now.
Dan.
Yeah,
You need to comply with zoning on accessory
Thank you.
structure.
okay, now I
You
thought
don't need a
Douglas,
permit under 200 square feet, you do not need a permit.
I don't need a permit.
Up to
I
200 square
thought
feet.
Douglas had a thing you could put it right on the line. You're saying Douglas don't have that law?
It's only for
No,
GBI.
it's
How
not
many
in
have
the
you got moved
bylaws.
Right, you're saying Douglas don't have that law, right?
No.
Okay, okay, if you're saying that, okay.
That's my
I just
understanding.
think you have
We
it.
do need it.
Tomorrow's another day.
Yeah,
So I say Douglas has that law.
Okay.
Yeah.
Okay.
Bring it in.
I think it'd give me the
I got the
citation on
book right
that.
here.
Yeah, right.
Yeah, you'll be happy.
That's right.
Douglas don't have that, Douglas has that law, but it's
Do you
just
know what
my
section
word.
it's in the zoning book?
No, I don't, but I know one
It would
thing,
be under accessory structures
yeah, probably.
use.
Well, it has to be under, 120 feet. It can only be
Square
10 by 12.
Square feet.
But it still has to
Square feet.
comply with zoning.
That's it.
You don't need a permit.
The building
120
inspector
square
just
feet.
said 200 square feet, so
Yeah.
That's for,
No, that's
under
for-
200 for a permit.
Right.
But
Yeah,
all
yeah, that's for a
accessory
permit.
structures
That's for a
need
permit,
to
yeah.
meet
For a shed,
setbacks.
you don't need, all you need is, you can
So
stay
it's
right
an
on
8
the
by
line.
12, you're all set.
Yeah,
You just gotta follow the zoning laws.
Correct.
and stay off the lot line, that's what you're saying, right?
Yes.
No, the setback.
The setback, right?
Setback.
I mean, you
don't,
got
and don't
dollar
build it in a
bet?
brook.
Dollar bet?
No, bet him, he's the one that's saying no. I'm
Dollar bet?
dollar bet, I'm not.
Attorney Pickard, continue. Go ahead, sir.
Dollar bet, you're on, okay.
So having said that, those are the issues for which we're seeking a variance. The lower shed, the shed to the southwest has been standing, I believe it's approximately 35 years, so it's been there a long time, but we're still looking to move it back onto Mr. Douglas' property. Again, as I said, the only issue is the setback. To that end, I drafted, and you have before you an amended application. It's not signed, primarily because I wanted really to inquire of the board how exactly you'd like to handle this issue.
I think we need to refile.
Yeah,
It would have to be re-advertised. eh?
Right.
Oh,
you'd have to re-advertise this, because it's, you change the,
totally different
yeah, you change the,
request.
The request.
it's different.
I don't necessarily disagree. Figured I'd ask the question. My second question and a follow-up to that is, given the fact that there are technically two structures for which we're seeking a variance. Yes, I agree. Would you require us to file two applications, or would one suffice?
Right?
The original violation letter, it said structures.
There's more than one.
So you would have to identify the structures that was in that letter and file your variance according to that.
I understand you to be saying that as long as that letter references multiple structures and we're looking for a variance with respect to those same structures, then we can do it on a single application.
That's what I would agree.
That's what
I just want to be sure that when we file it again.
Because I had a problem with your existing one, because it only says shed,
Yeah.
single.
The reason, if I
So,
may, the reason
multiple.
for that was because the shed that was entirely on the property, that is to say,
But
Mr.
again, your
Pollard.
violation letter says structures.
It does, but there's a
Sheds.
10-year statute of
So-
limitations on sheds, so we weren't really concerned about that. But be that as it may, we're seeking to move it and comply with that.
I've got one question.
Go ahead, John.
Regards to the plans.
Yes,
There's one that says on the very bottom, the kennel. Is that gonna be torn down and moved down?
the
or-
kennel is, yes, there's an agreement. So there's, you'll notice there's a whole lot of fencing and there's a whole bunch of stuff, let's just put it that way. And the private parties are agreeing that, other than the particular structures we're looking to address here, the other things will be removed. So
So that
they're
kennel-
in agreement
so
with
what you're
respect to all
saying
that.
is that kennel will be removed, okay.
Yes. And there are some, if you look at the diagram on the right, which shows the entire Dudley parcel,
Yep.
there are some other smaller, what you might consider improvements, but the building inspector previously said that those don't require any sort of setbacks or anything. So there's a carport, for instance, but it's not attached to the
Not
ground.
attached, it's not
Exactly.
structural.
That's correct.
Can I ask a question?
Sure, go ahead, Mark.
So the shed, the big shed in the back, how many square feet is that?
Looks bigger than
There's no permit pulled on that.
The larger shed up to the north,
Yeah.
east you talking about?
The top one.
Yeah.
I don't know what shed he's talking about.
Yeah, he's talking about this shed.
The
biggest
large
one.
shed that you're trying to get the neighbor's land for.
That one? No, there was no permit for that.
No, what's the size of it?
What's
Yes.
that?
Oh, the exact dimensions?
Approximately exact.
As far as what the.
It was larger than 12 by
Yeah,
12.
Maybe,
12 by
I
8.
don't have the
They're
exact
just trying to be-
dimensions, maybe like
They're trying to
18
be cute
by
about it. What they should be showing
14,
is the
something like that.
building envelope on the
16,
plot.
16 foot, 16 by something, I don't know. I wish somebody would have asked me, I would have had it.
All right, so you didn't pull a permit for it?
No, I told you, there's no permit for it.
All right, well, you gotta pull a permit for it. It's over 200 square feet.
How long has that shed been?
I thought we were looking for a variance here.
Yeah.
Why do I need a permit if
Well,
I'm getting a variance?
How long ago was the shed put up?
About 6.5 years ago.
Yeah, you need a
Well, the
permit.
building inspector's sitting in the room and you're telling me there's a shed on a property that's over 200 square feet. That's not, doesn't have a permit.
Well,
So
that
whether
was,
it's a
that was,
variance
that was
or not.
discussed in the previous meeting.
Yeah.
I don't think it was.
I wasn't here for the meeting.
It was discussed and no permit was
Well,
taken.
no permit, we'll take,
It
we'll
should have
No,
been.
there's no permit.
Right,
We
well,
didn't waive that.
That
Mr.
doesn't-
Pickett, also, if you're gonna refile this, there's a lot of missing information. I mean, this is really a pretty poor presentation.
Jim.
Now, how many years?
We shouldn't be guessing about the size of buildings. It should say right on it.
Yeah.
What size the building is,
Yeah.
what the distance is, and, I mean, it's hard to make decisions when you don't have all the information.
You're
That's what-
you're
that's
talking,
what's
well,
going on now, Lou.
I
Trying to
don't know
figure it
that,
out.
in fairness, I think that the reason that those distances aren't on there is because, if you recall, the shed to the northeast, we were contemplating moving it. And so the distances were established in the application. In other words, they don't show up on the plan because its current location is over the line. We were gonna move it the exact distance required based on the variance that we were seeking from this board. The shed, the lower shed, we weren't seeking to move at that time. That's why those distances aren't there as well.
Okay, but
I-
I'm saying when you come back,
Yes.
you reapply, we need to
Sure.
have those
Well,
sizes of the sheds
I
and the
understand.
distance. But also, I personally would be interested in knowing how far it is from Wallis Road to where you're proposing to move this shed. I mean, personally, I see no reason why you can't meet the front setback and apply for whatever's left.
Yeah. Give us the 50 feet in the front and try to apply for the rest of it.
sure, we could put those distances in as well.
And now, may I say one thing?
Sure.
Keep in mind, you said that's about 10 years old, so,
6.
oh,
6.5.
is it 10 or 6?
6. He
There's
said
a
6,
no
7.
That's, being totally honest, it's about 6.5, 7 years old.
Okay. Now, well, you know.
I didn't know I needed a permit,
Yeah,
I'm
that's
sorry.
okay. Yeah, no, you don't need one.
If it's 10.
Well, we're not here to give people advice,
No,
we're
no,
not
no,
attorneys,
no, no,
okay?
I'm
He has
just
an
telling
attorney
you.
right there, so
Right.
why don't we focus on their
Okay,
application?
Our needs.
Well, it was built in a certain year, and that, if it was built so many years, am I right or wrong, you don't need a permit. You only need a permit, okay, if it was beyond, if it was before 6 years.
You know, it's not your interpretation, Louis,
Okay.
it's the building
You got
commissioner's
that, Laura, right?
interpretation.
There's a 10-year statute of limitations on buildings, but
Yeah, you don't know it, right?
I just said there's a 10-year statute of limitations on buildings.
No, with a permit.
There's no permit for that one,
Right,
unfortunately.
so, I mean, that's what you gotta look up. With the
Okay,
permit.
but it's the building commissioner's interpretation, Lou, not ours.
Okay.
So,
So-
to satisfy this, we'll need the setbacks, the size of the garages.
Yep.
Complete.
Complete.
A complete,
Yeah.
like we expect from everybody.
Yep.
But,
I
I
don't mean to
I
be
have no
difficult.
idea whether this is gonna fly. I mean, we're gonna have our attorney look at it.
Yeah.
As a zoning board member, right now there's snow all over the place, but we can't even go on the property.
Yeah,
So
there's no
it doesn't
trespassing
even
signs.
allow, I'm not sure what your client is thinking, to be honest. He's looking for some
Relief from us.
relief, but we can't go on to look at his property. So that's-
Could I answer that statement?
As
I
soon
never
as,
said
you're not
anybody could
recognized,
go on my
sir. You
property.
haven't been
No.
recognized,
If I
sir.
may, I was not aware that had been a formal request.
Well, we got a letter.
We got a
To stay
letter in
off
the
the
mail saying
property.
that, stating that they don't want anybody on the property. There's
Not what
no
it said.
trespassing
It's our
signs.
goal is to make informed decisions, and
By looking at it.
I suspect that if the board wanted to schedule a time to look at the property, it wouldn't be an issue. That's understandable.
Well, a neighbor,
I asked Henry to.
you haven't been recognized, sir.
Mr. Dudley, would you just, if you'd like.
Just tell us your name, sir, that's all you gotta do.
My name's Dan Dudley. Can I have permission to say something?
Yes, you may.
Yes, yes.
Thank you.
Say your name.
I'm Dan Dudley.
Okay, that's it.
I never said anybody couldn't come on my property. What I said is I didn't want people on my property without an appointment so that I could show them around. That's what I said, all right? So my words were completely moved around and made it so it sound like I was some sort of a monster, which isn't the first time that's happened at this meeting.
If I may, again, if the board wishes to go and take a look, I'm confident that can be arranged. It's not an issue.
So we should contact your office.
Yes.
Like,
Okay.
I don't see, I think it's a great idea.
Mike?
I don't need to go there at all. All I need to do is see dimensions. And if we could get the dimensions on the plan, it's a pretty flat rectangle lot. Show me where everything's fitting on the lot. I'm thinking that your building envelope's only 5 feet wide, so there's probably not really much sense to have that. So show me how far you are from the front property line, sides, rears, instead of trying to guess size of buildings and where it sits and all this other stuff. That way we can make an educated decision on what we're doing.
Probably those zoning setback lines should be on that, when you put the new application.
Well, the building envelope?
Yes.
Yeah, but it's gonna be a 5-foot strip down the center of it.
yeah.
Well, whatever it may be.
No,
it should be on the
if you're
plan.
50,
what it
if
is,
you're
I
50 in the front, you're 25 in the back, it's only an 80-foot lot, you're gonna have a 5-foot slice down the center. So I don't think, other than his TV antenna or anything, within the building envelope. But if we had some dimensions, it would be helpful.
Yeah, I understand the request.
Just
It's not
to
a problem.
show where it is.
Are there any other concerns?
All the building inspector make sure applies for a permit.
Well, he's gotta move it. Now, excuse me, I just got a question, okay? Not giving no advice, just asking a question here.
We're watching you, Louis.
Have I got the floor?
I don't mind
the floor.
They're not
Yes,
filed, they have not
Okay.
said one sign, but if you'd like to.
Now, are you listening?
I'm listening, Lou,
Okay.
please.
Now, these two guys are getting along, right? Am I right?
Getting along
I hear that from both of you?
unusually
You're all
well, I
getting
can
along.
say.
We have.
I made a deal.
Excuse
Okay,
me.
good. That's
Can I
all.
talk? Dan Dudley, can I
Who's
talk?
talking to who?
I'm talking to, I got the floor.
Well, Louis, your head's over that way, talking to someone over there.
I'm sorry.
You wanted to say something.
Okay.
Do it
all
like
I'm
a member of
saying
the
is
board.
this here, is that number one, these people they're in complete, they understand it, they gotta do what they gotta do, okay? I don't see why they need anything from us.
Well, that's your opinion.
Yeah, that's my opinion. Why would they need anything? He could make this line bigger if he wants. The only thing you're gonna do, you're gonna move this deck from here over to here?
Again, we're not here,
Oh,
Lou,
okay, I'm
to give
sorry.
people guidance. We're here to make decisions based on their proposal to us
And our zoning bylaws.
and follow.
In our zoning bylaws, I'm
Right.
100% in thing, but I don't understand why two people are getting along, they're neighbors, they should mind their own, they should take their own business. We should not have to be involved. And we got the building inspector here involved, and, the poor guy, he's a new
They've
building
been,
inspector.
they've been written up. He's been written up by
I
the
know,
building
I
inspector
know.
for having zoning violations. That's why they're here.
Yep, but then, what are you gonna do? They're neighbors.
Anything else?
Okay,
Simple, so
no,
we can get it
I
messed
think
up,
you-
I think.
You're looking for a new partner?
Hey,
We almost work together from time to time, isn't that right?
that's right, buddy.
Wasn't that Joe Pesci that did that one?
Anyway, so you know what you need.
I believe I do.
Yeah, so he's gotta reapply, correct?
Yep.
Yes, assuming
So
that.
then, are we going
Are
to?
you gonna withdraw?
We would like to withdraw as opposed to you denying the application,
Yeah,
yes.
that would be good.
Okay.
Need a motion on that?
Um,
Want to vote on that?
Yeah, we certainly.
I would move on.
Yeah, we
withdraw
do.
the application.
I'll
Yeah, I
move-
don't have, and I guess I can just write up a note.
Yeah,
Yeah,
just
we're
right
gonna do
along.
something.
I'll
she's
move
got-
that we accept the
She may have.
verbal withdrawal
He's gonna
From
put
the
it in writing
attorney.
now, too.
representing Mr. Dudley.
I'll second it.
Yeah,
Okay, we
we're
have
on a
a,
roll.
we have a motion by Mrs. Holmes, second by Mr. Bombara, to accept the withdrawal from Dan Dudley for
Case number 2.
case number, yep, thank you,
Hold on.
2019-01.
Thank you.
Any further discussion? All in favor?
Aye.
Aye. Okay. Attorney Pickard, do you think you'll have this application in for next month's meeting?
I believe I will.
Well, we just want to,
Yeah,
Have
I'll
town
do it as quickly as I can.
if you, we just want to give our town council
I understand, Mr. Chairman.
notice to
No problem.
be present.
Well, he's gonna be here anyways for the other one.
Not bad, Mike.
I want him to be.
Bet dollar on that one?
Dollar on which one?
All right, again.
Oh, yeah? I'll take that dollar. Come on.
It's a lot of dollars, Lou.
Hey,
There's nothing more than I want to do with
Now
give you a
listen,
dollar.
kid.
That would be wonderful.
That'll hurt you more than anything.
If I may just.
Just give me the dollar.
Oh,
Just to give me the dollar.
I'll take it.
Give it to me.
Give it to her.
Give it to me.
I have to have town clerk stamp it. Thank you.
all right.
Thank you.
This is going-
Thank you.
don't have any words,
I have a
don't
question.
any nothing.
Mr. Dudley
ask a
has,
question?
Mr. Dudley has a question.
Yes.
Can he ask it, please?
He just withdrew his application.
Yeah, well, he just wants to ask a question.
Go ahead.
Okay, so what's gonna be happening with the new building inspector? Is he gonna start giving me more tickets now?
If you have zoning violations, that's,
Yeah, he's a good guy.
zoning violations are zoning violations.
Don't
Lou.
speak for
No, I'm
somebody
not,
else.
I'd like to know what's gonna happen now. I mean, we're trying to work this out. Patrick and I have worked this out. It's taken us a year to get to the point where we're friends, we're shaking hands, we're getting along, we're doing projects together. I just hope the town isn't gonna throw a whammy into it.
Whose fault is it in the beginning,
I didn't put that shed there, my father put that there 35 years ago.
with the new one?
And when I found out, I didn't know it needed a permit, and I didn't know it was on his land.
Oh, okay.
But you should have.
You should-
Well, we'll discuss.
Discuss it.
You should have.
Council him.
Okay, so I should have. I didn't.
Yeah,
So,
yeah.
We're not gonna punish you anymore
We'll talk to him.
Tonight.
You're okay.
tonight.
All right, the next agenda item is the
Go in
Come on,
peace.
how's it going?
minutes.
Jay confirmed for next meeting.
He did? Okay, thank you.
Thank you, Bill.
He's got that new right lawn.
Oh,
I'm
They're gonna have a
requesting a site visit
discussion
tomorrow.
back.
I want to look at that shit. I
I'm
wanna see how
leaving
big
to
it
go
is.
to Maryland until next week.
All right,
Excuse me,
next
Mr. Dudley? This is,
Outside.
the meeting's in process. You want to talk in the hallway, feel free.
I'm leaving tomorrow
week.
morning.
Go outside.
Sure, Mark. Whatever you want to do. Okay, next agenda item is the minute. Agenda item is case number 2019-03, public hearing for Dan Dudley, 160 Wallis Street. DD application was 4/17/2019. The application was published in the Worcester Telegram and Gazette, also posted at the Town Hall and read as follows. The Town of Douglas Zoning Board of Appeals will hold a public hearing at 7:15 PM on Wednesday, May 8th, 2019, in the Douglas Municipal Center Community Meeting Room, 29 Depot Street, Douglas, Mass., to hear the following application. Dan Dudley is requesting a variance in a rural agricultural RA zone district pursuant to the Douglas zoning bylaws for a rear yard setback and a side yard setback for two sheds. The bylaw requires a rear yard setback of 25 feet and a side yard setback of 25 feet. The applicant proposes a rear yard setback of 4 feet in connection with a shed located to the northwest, shed number 1 on the plan, and a rear yard setback of 2 feet in connection with shed located to the southwest, shed number 2 on the plan. The applicant proposes side yard setbacks of 5 feet on each side of shed number 1. The property is located at 160 Wallis Street, Assessors Map 158, Parcel 19. A copy of the application may be viewed at the Community Development Department during regular business hours. Any person interested or wishing to be heard on the proposed application should appear at the time and place designated. Maria, did we get all the certified mailings?
Yes.
Okay. Okay, and the four of us will be voting on this. It'll be Mr. Holland, myself, Mrs. Holmes, and Mr. Fitzpatrick. Okay, the applicant or representative.
Before we start, my math is right, there's only 4 people here.
Right. Correct.
So,
You need 4 votes.
correct.
Mhm.
You want to,
High risk kind of thing. More importantly, Since this was filed, there's been further discussions between the neighbors, and there's a slight alteration to the proposal, which is going to increase the nonconformity. So, I mean, I'm fine with it, but, you know, if you want to re-advertise to show the additional nonconformity, we should probably do that before we proceed with the public hearing, so we don't have any problems in that regard.
That should be advertised properly, I agree.
So, and I can tell you what the change is. If you have the little sketch,
This packet.
well, I'll just hand out the revised.
This
one.
right here?
So, yeah, I'll just show you the difference.
Oh, that's the revised one?
Yeah.
Thank you.
As I say, the neighbors have had, you know, discussions, and so we had originally proposed a 5-foot side lot setback on shed number 1, and the neighbors would like to see that reduced to 4 feet, so that it changes the total width to 20 feet from 22 feet. You'll see that it's marked on there. So that increases the nonconformity by 1 foot on either side of the shed. You see where we're going with that?
No, I'm not gonna talk about the case since the case isn't, we're
Yeah,
not
right,
gonna
I
open
guess
it.
the best bet would be
But,
just
I mean, because I've got questions.
have you, I guess, refile.
Well, we could just re-advertise, can't we?
The document that you're submitting here says one thing, and you're telling us it's not, up to refiling, right?
I would say it's closer than what
Can't
was
amend it.
advertised, closer
Yeah.
than what was filed
Right.
in the application. So I would say it would require a new application and new advertising.
Yep. Let's do that. All right.
So do you want to withdraw this application?
If that's the board's decision, that's what we'll do, we'll refile it.
Well, there's a change, and the change is,
I don't think it'd be the board's decision. I think the request would come from the applicant on the withdrawal,
Yeah,
just procedurally.
yeah. I mean, it's a substantive enough change that, that impacts the bylaw.
Then we would request that we be allowed to withdraw without prejudice.
okay, the applicant has a request.
I'm move that we accept the request for withdrawal without
Second.
prejudice.
Okay, we have a motion by Mr. Holmes, seconded by Mrs. Holmes. All in favor?
Aye.
Aye. Okay, so
Okay,
you
I didn't see it.
plan to come to the June meeting? Is that-
Maria, when does a request have to be filed by? Do you have a date from Mr. Attorney Lane?
Next meeting is the 12th.
Yep. So it's how many days, weeks before?
Let's see, June 12th, the deadline is May 22nd.
Okay.
What's the file number on this?
Yep.
You might be home to watch Chronicle.
Good Lord, I wouldn't go home. Give me a little credit. Thank you.
Thank you.
Give it to the teacher.
Red pen out.
Okay, no?
Well, thanks for coming to let us know the sad news. C'est la
I
vie.
know before yesterday, I would let you know sooner.
Really? Really?
All right, we'll see you next month.
Thank you.
Good night.
Thank you.
Good night.
Okay, we have minutes of March 13th. And all right, the next agenda item is public hearing for Dan Dudley, case number 2019-08, 160 Wallis Street. Date of his application was July 23rd. And it was advertised, this hearing was advertised in the Telegram and Gazette and posted in the Town Hall, and it read as follows. The Town of Douglas Zoning Board of Appeals will hold a public hearing at 7:15 on Wednesday, August 13th. For some reason this says May. In the Douglas Municipal Center, Community Meeting Room, 29 Depot Street, Douglas, Mass., to hear the application. Public hearing for Dan Dudley is requesting a variance in a rural agricultural RA zone district pursuant to the Douglas zoning bylaws for a rear yard setback and a side yard setback for 2 sheds. The bylaw requires a rear yard setback of 25 feet and a side yard setback of 25 feet. The applicant proposes a rear yard setback of 4 feet in connection with the shed located to the northwest, shed number 1 on the plan, and a rear yard setback of 2 feet in connection with the shed located to the southwest, shed number 2 on the plan. The applicant proposes side yard setbacks of 5 feet on each side of shed number 1. The property is located at 160 160 Wallis Street, Assessors Map 158, Parcel 19.
Thank you.
Okay. The planning board has sent in a saying that they had no objections to the attached request. And the voting members on tonight's, in this case, are Mrs. Holmes, Mr. Fitzpatrick, Mr. Tassino, Mr. Bombara, and myself, the applicant and the representative.
Thank you, Mr. Chairman and board members. I'm Henry Lane on behalf of the applicant, who is Mr. Dudley, who is seated in the rear corner. And also seated is Mr. Pollard, the immediate butter to the west. This is, I think, the 3rd time we've been here, so you probably know who we all are.
Yes.
And I think we've finally come to a conclusion that at least the neighbors can live with. So Mr. Pollard and Mr. Dudley have gone through this in great detail, and they've basically come to an accommodation that will allow the neighbors to return some integrity to the common property line and also accommodate the sheds that were built over a period of many years. With some disregard to the actual property line. So, in order to bring everything into compliance, we prepared this plan, and Mr. Pollard has graciously agreed to convey a little strip of land to Mr. Dudley so that we can actually get the shed number 1 back onto Mr. Dudley's property. And Mr. Dudley has agreed to take the shed number 2, which is currently on Mr. Pollard's property, and move it onto his own property. However, we sort of, part of the dilemma is that we have a very shallow lot. And in the location of these buildings, there's actually not enough physical space to actually comply with setbacks for these buildings, because it just isn't a lot of depth to accommodate that. And, you know, the sheds have to stay in a place that allows for the existing buildings to be utilized in a functional way. So this seems to be the best resolution that unfortunately doesn't comply with the literal requirements of the zoning bylaws, but does accommodate the needs of the neighbors. So, as you indicated earlier, on shed number 1, we're looking for a variance for the setback to 4 feet, and similarly to the sideline, 4 feet, so that we can accommodate that shed. And then with respect to shed 2, we're going to move that onto Mr. Dudley's property, and we're asking for a 2-foot setback as opposed to the 25 that's required. So that's the simple explanation. As I indicated, theoretically, this is a very long lot, and if you put these buildings all the way up against Shady Lane, you could theoretically meet the setback requirements, but it would be so far from the existing dwellings that it would be essentially useless. So, as I indicated in the application, Mr. Dudley has his emergency generator and other supplies that he has occasion to use. And if it's at the far end of the property, several hundred feet away, it certainly is not accessible, and certainly during inclement weather would not be functional. So we're sort of have that dilemma, and if we move it straight to the east, it kind of blocks his entrance to his house. So that's a problem. If he moves, he's already encroaching on the theoretical setback for his reserved septic area, so he really can't move it any further in the southerly direction either. So he's kind of boxed in. As I say, unfortunately, a lot of this was done years ago. Some of it actually by his dad, 40 years ago. Shed number 1 was more recently, but as you can see from the property, there's actually a fence line there, and I guess Mr. Dudley made the reasonable assumption, I guess, that the fence line was the property line, and now finds out that it isn't, and finds himself in this dilemma. So we're asking for some mercy, shall we say, some grace from the board to accommodate the situation that we have, and, as I say, really improve it to a great extent. Although it's really an imperfect solution, but it's the best that we have available.
Okay, Lou?
Is everybody happy with that?
Mr. Pollard is sitting right there.
Are you guys all happy? Everybody's happy?
Yes, sir, we're Ducky.
Okay, as long as you guys are happy, I'm on your side.
Point of order, Mr. Chairman.
Yeah. If anyone wants to speak, you're welcome to speak, but we just need to be identified for the minutes. So,
And they should be speaking to you.
yes. Okay. Anybody else have any other questions on this application?
I do, Mr. Chairman, I'm going to ask him, did he ever get a permit on shed number 1 or number 2 from the building department?
As I say, shed number 2.
I mean, we're just voting on something he's never got refused for, and now he's asking for a variance that it's something he's never been approved.
Right, well, as I say,
But I mean, the shed is 16 by 12.
Yeah.
I can't build that in my yard.
No, we understand that, and we've had extensive discussions, and the building inspector has indicated that we have to apply for a building permit, but we can't get a building permit without a variance. It's a catch-22. We can't get a building permit unless we have a variance.
The shed's up, that's what I'm saying.
Well, I understand that, but,
Yeah.
and the understanding in the agreement is that if we get the variance, he will apply for the building permit and he will pay the fee, et cetera. Shed number 2 was built by his dad some 40 years ago. We have no idea what the situation there was. If he needs a permit, he'll apply for it, that's.
Yeah.
But, we've had ongoing discussions.
I mean, one other correction I want to make is that his wife told us that he knew that he was on someone else's property when he did this. So, no, I'm just correcting you because it came up months ago, that's all. So, anyway, Mike, you got something?
Oh, yeah, you done?
Okay. Yeah, I'm done.
Yeah, good.
Pass it down when you're done.
Can we use this as a symbol? Other than the inconvenience of moving his generator during a storm or whatever, which I do the same thing, I don't know if anybody else does, he could at least meet 3 of his setbacks by utilizing the other 50% of his property.
No, there's no question that, as I indicated going in, if you go to the very northerly side of the property, there is theoretically enough setback required, so that he can meet those setback requirements if he, shifts the shape of the shed, or the orientation of the shed, and moves it, several hundred feet from the building. But at that point, you got a foot and a half of snow on the ground, and you're trying to get your generator, and you got to drag it, a couple hundred feet when you're a senior citizen. That's a pretty.
Technically, I'm a senior citizen too, and I.
But you're not as senior as Mr. Douglas.
I feel the same way as Mike. You can buy a 7,500-foot cord, leave the generator in the shed,
And you could go right
and run
behind
it
these
down
other
to
2
connect to
buildings.
the house.
Not that far. You don't have to go up the shady lane, you can go right behind these.
Yeah, in the carport, in the garage.
And you mentioned the carport in the garage when Larry went out there last year. In his violation letter, he said multiple buildings. I don't think it was just referring to these 2 sheds. I think he was referring to everything that was on there. But we're here for the 2 sheds, so I'll leave it at that. I'm not gonna
As I understand
confuse
it,
but
it's been a moving target, and I remember the first time we were here, we specifically asked which sheds. We were initially told it was Shed 1 and Shed 2. Then the town attorney said it was Shed 1 and the tent.
If we're gonna go back, one of your applications, probably on the previous one to this one, there was interference with the septic system, which is also on here, and I requested the location of that septic system, and we got a hand-drawn sketch of a cesspool. So now we have a drawn septic system. I actually stopped in the Board of Health, and they have no record of it. Maria in her file has a proposed septic system, but it doesn't have a stamp or a sign-off, so I don't even know if the septic system's there, to be honest with you.
Well, we went through that, and we do have the Board of Health as-built plan.
Okay.
And then, as you'll see from the note, because there was some discrepancy in what the as-built showed, we had a ground-penetrating radar company come out and actually physically locate it on the ground. So we are fairly certain, and that was at Ms. Holmes' request, that we do that, and we did it. You asked us to locate the septic system.
It's been so long ago, I forgot.
But as an accommodation, we spent, crazy amounts of money to have ground penetrating radar out there to actually, address the issue, so there's no question where it is. That's where it is. That's where the trenches are. That's where the opening to the septic tank is. That's, without physically excavating it, that's as good as we could do.
Right.
Thank you. Yeah, what type of foundation is for the shed number 1, please?
It's a gravel base.
Cement
It doesn't have a poured foundation.
Has anyone done any research on the cost to move that?
Yeah, we've looked at moving it.
I'm sorry?
We did look at, it's physically movable. It's not, I'm not going to lie to you. It's physically movable. One could, with the right equipment and enough money, one could move that shed. It was moved onto the site. It can be moved off the
They
site.
do that all the time, so I'm just wondering if it's not installed into the ground.
Nope.
It's on top. And what year was that built?
About 7 or 8 years ago. I don't know the exact date, but I know it's in that range. That's when it was, I don't know when it was built, that's when it was installed.
2010 plus.
What's
plus
that?
2010 plus or minus?
Yeah.
That's 9 years. Just wondering if we, in any transition in the town government at the time. Shed number 2, you were going over south and what's north and whatever, and I was not following you. So my question is simply, you're moving that shed,
Yep.
and you're leaving 2 feet from the back
Right.
property line. Why is that? Why cannot that be moved further front?
Well, I mean, theoretically, it can be,
Okay.
but it, you're putting it into somebody's front lawn.
Oh, well, that's too bad.
It is too bad.
Could I say something?
75 feet.
Okay.
Do you have anything else, Henry?
What's that?
No, do you have anything else on that?
No, I.
Okay. All right, who would like to be recognized?
I'd like to say something about that point. It wouldn't be in the middle of my lawn, it would be in the middle of a rock field. I don't have a lawn. It's all rocks, big boulders. There's no other place to put it.
Anybody?
Cover the boulders with it.
I have to say, I'm on board with Mike. I would have no problem if they met 3 of the setbacks
Yeah.
and giving a variance for the 4th one.
Yep.
And I don't see the terrible inconvenience placing it directly behind the house or by these carports. And you could meet the front setback, both sides, and get a variance for the rear setback. And I mean, make a true effort to meet the zoning bylaws. That's my take on it. I think it's fixable.
It is. It is.
With a variance, for whatever it may be. Rear setback,
Yeah.
2 sides would be fine, and meet the front yard setback. You know, if
You're
it was
talking
placed
about
up
number
here,
2?
both.
Number 1 and 2.
You know,
Number 1
up
could be
here,
easily moved right up to
up here.
its carport.
Yeah.
And I don't see it, based on this, it's not a great scale, but I think it could be put within 50 feet of the house. Meet the sideline setbacks, meet the front setback, and I'd be on board to give them a variance.
Those carports and.
Yep.
And I
and
think,
meet it.
I recall, I think those are just tents,
The carport is, yeah.
so they could be easily moved.
Mhm.
And,
I think one
I'll
of
go
them,
behind them.
potentially, I think the other one.
Well, the other one appears to be maybe just, it says garage on here. Appears to be maybe a little longer than the shed number 1. But even that, if you could move the carport and put the other garage behind that one, closer to the garage that we just mentioned, so.
I mean,
He has a chance to meet most of the setbacks.
It's a large piece of land behind
Yep.
Yeah,
this
Yeah,
garage
yeah,
up
just
up
that
to the end.
it's just as remote, It's like,
Excuse me? Oh, yeah, what I was getting at is here, 2 people, neighbors, they're completely happy with each other, and I don't even see why, I mean, if one of those were my neighbors, and we should have made a deal before we even get here the first time, what's the big deal? They're both
The big deal
Friends?
is the little book that they have called zoning bylaws. That's the
Yeah,
big deal.
100%.
They made it.
100%. But they're neighbors, they gotta get along, and they seem like they're getting along. Why would we get involved?
I think they, regardless,
zoning.
either way that it goes, they would
Like-
still get along afterwards. That
Yeah,
wouldn't,
but you see-
that wouldn't jeopardize their relationship.
Nope.
Well, I think it would if you put a burden where it costs $10,000 to move something, and they're not really, I mean, why would you put a burden like that on somebody if they both get along?
Yeah, I think $10,000 might be a little rich
yeah, I think it'd
for
be way
moving,
rich.
for moving a shed, because if they get 10,000 to move a shed, I'm in the wrong business.
Yeah, well, you know that he is, but that's beside the point.
Yeah, I'm
Yeah.
doing
No,
fine with what
no, I just
I'm
don't
doing,
know
so.
why we would get involved with neighbors.
Well, for one thing, it sets a precedent.
Sets a precedent for the rest
It
of
really
his board
isn't
members,
neighbors.
It's, we want to help people through the process. And if we can find a way to fulfill
Make
the
things
needs of
right.
them, make them right.
This
Well, that's
board,
all.
We've had multiple applicants that have come in before this one
Mhm.
that they wanted to put something because that's where they wanted it. But they had other options.
Yes.
So we-
yeah, but these are already here.
And we've also been very careful in going down to small variances, like, 2 foot, 2 foot is,
Then we set a precedent, then everybody else
And
wants to be 2
4
feet
foot
from the
is-
lot line.
No, it's just- Excuse me, this board cannot set a precedence. It can't set one.
How do you look
because
at- how do you-
everything is, you're right, everything is totally,
set one.
totally individual.
If it could set one, I wouldn't be in court
That's
with
correct,
my
Louis.
place
That's
up
right.
on Wall Mike, because it can't set one.
Right.
Okay, but I'll tell you right now, I see 2 people are getting along. They shouldn't even came here in the first place. But they did,
What?
but they
Well,
did.
they were cited by the
Perhaps,
town for failing to follow the town's zoning bylaws, that's all.
Perhaps, if I can ask for the board's indulgence one more time, could we ask that?
I need my hearing aid, I gotta turn it on.
All right, let me
Clear that
turn that up
throat.
for you.
Yeah, make believe he's collecting money.
Perhaps, now that we've sort of heard the board's opinion, unless there's other members of the public that want to be heard, I'd like to ask for the board's indulgence to continue this for a month so we can look at these options and decide if we want to go forward or withdraw it at that point.
That would be okay with me.
Yeah, we've had so many continuances in this case, it's just,
Let me just ask one question. Did
Yeah.
Mr. Dudley pay to re-advertise this?
He did.
Okay.
I mean, I'd like to see it get resolved. This case
I
has
know,
been
I
dragging
know.
for.
Yep.
Well, we know what happens if we're gonna deny this. You won't be able to come back. You just, once you talk to your, in my opinion, Mr. Chairman,
Mhm.
talk to your client and see what you do.
Well, that's what I say, I want to look at, you may be, I suspect it's a high probability we'll withdraw it if we can't come up with something that's reasonable.
If you withdraw it, you'll be in violation of the town's zoning bylaws, right?
That's true.
Okay.
Would that make him subject to being fined, Mark?
Yes, it would. So, we haven't fined
Needs to be
him to this
solved.
point because he's been working to try to resolve this, so at some point when you guys say no, the fine's gotta start until the building's moved.
It needs to be solved.
I mean, I don't see any major hardship, just get a variance, a rear yard set variance, and you meet the sidelines, you meet the front setback, and
Well, we still have to do that, so that's why I guess we're asking for the indulgence for a month.
You just
one
want to do a little measuring and
Yeah.
figure out how much where.
Yeah.
Mike,
Do we have to accept their withdrawal?
I don't believe we do.
No. Okay. So, in my opinion, it's a new application, technically. They're asking for a month to compare notes and come up with a better solution than what's here. I don't think that's unreasonable. As far as withdrawing at this point, because this has been going on for close to a year now, I wouldn't be inclined to do it if I didn't have to.
And I'll agree with you.
I'm on board with that as well.
So, do you need a motion to
Continue.
continue?
Yeah,
Right.
continue with the understanding there'll be no more continuances?
Well, I think that's pretty clear. Mr. Lane got what I was saying, so.
I mean, the case does have a history of
no, I know
continuances that
that.
end up being 3 months down the road instead of 1 month down the road.
Yep.
And I think it's just time to.
I would like to see this resolved,
Finish.
I would like to
Yes.
see this resolved next month, one way or the other.
Mhm.
Okay.
I think,
If he was to move it, how long would we give him to move it?
I think we'll talk about that next month.
Yep, let them do that.
We don't even know what they want to do.
Let them
Well,
do it.
I'm
Let
not
them
trying
do
to be difficult, but
No.
I'm not gonna,
We're
I don't want to
jumping
deal with
the gun
hypotheticals. I
here,
want to
so
deal
to
with the actual,
Yeah.
what's going
Gun
on
talk.
with it.
just before we get that far, is it clear to you, I guess, where the board stands on?
That's very clear.
Okay.
All right. Mike, you have a motion?
Yeah, what's the case number on this thing? All right, that's right. Yeah, so I make a motion to continue case number 2019-08 until next month,
Second.
September 11th
September
at
11th,
7:15.
at 7:15 per Maria.
It's a dark day.
Okay, we have a motion by Mr. Fitzpatrick. Do we have a second?
I did.
Oh, I'm sorry, seconded by Mrs. Holmes. All in favor?
Aye.
Aye. We'll see you next month.
Thank you.
Louis said no.
You said no.
All right, so it's
Louis said no.
4 in favor, 1 opposed. Mr. Tissino opposed.
Thank you.
Thank you.
Keep that.
Gotta give you something to do.
He made his point.
Equipment were you moving in your garage today?
Well, have you heard of the business?
That was my business.
Because of
Oh, was your
He had a
business?
guy call me up that was moving it, I helped him out, but tell me, what the fuck are you doing in your garage? He's moving his equipment.
Okay, you know what?
We
We're
got
in the middle of a
another,
zoning board meeting, so.
yeah.
Okay, the next agenda item is the continued public hearing for Dan Dudley, case number 2019-08. Mr. Lane, would you like to join us?
Mr. Lane, how's it going? Lovely people here.
All right, I guess since the last time we were here, we have not made a lot of progress. So unfortunately, we're gonna have to ask that it be continued for another month.
Could someone refresh my memory and tell me what were we going to be doing?
Well, we
What
were-
progress, how were we going to make
We
progress?
were looking to see if we could work out some other arrangement.
Yeah.
But so far, we have been unable to do that.
And can you tell me what type of actions have been, or what's been done to try to get to that other arrangement or another arrangement?
Well, I can't go into great detail,
Okay.
but we have, but we
I mean,
anticipate.
other than time passing,
Yeah, no, we,
some actions have been taken?
some actions have been taken,
Okay.
which I am not at liberty to
Mhm.
disclose, and I've been advised that in the coming month, we should be able to achieve a resolution.
Really?
We had a discussion last month that we
Yeah.
tried to...
This was gonna be it. This is gonna be it.
Yeah.
Last one, and I was the one that suggested it, let it get done.
What was the suggestion that Mike
That's what
made?
The drafter
Was
was
it you?
thinking, no, he was thinking, I agree with him, just moving in a different direction
Mhm.
on the other side of the property, where it was less non-conforming.
Yeah, yeah, yeah.
So it's 2 feet off, we want more than that. So, and he has ways and means of doing that, moving to the other side of the house there. So,
My recollection is the board was pretty clear, we wanted to resolve this tonight. It's been over a
Yeah.
year, I
Yeah.
believe, since it originally started. I'm sorry, Joe, did you?
No,
I interrupt you?
Mike wants, no, I'm good.
Oh, I've given it a little thought, and he obviously needs some relief because the width of his lot is 85 feet, 85.78 feet. So 50 and 25, 75, so he's got a 10-foot building envelope.
Problem, yeah.
2 feet off the property line is a stretch, 4 feet is a stretch. Myself, I would be inclined to cut that setback in half, where he has a challenge because it's a narrow lot. So if we cut that setback in half, to 12 feet off the back line, he essentially creates a building envelope that's 23 feet by 530 feet long. It should give him ample space to figure out a spot to put it. And we did venture down this path last time we talked, so to be proactive with it, I gave it a little thought to see what would be a reasonable approach. Obviously, it's a problem lot because it's narrow.
Yeah.
Just 2 feet off the rear line. Today, you have 2 neighbors that are getting along. One neighbor moves and a new neighbor comes in, is not always the case, and I understand that the variance gets granted. You're stuck with the situation, but I'm just not comfortable being that close to the property line. Not when we have other options.
Right.
Yeah, I mean, I really, like I said all along, I don't, you know, I mean, if you give them 2 feet, what's the big deal?
What's the big deal of having it 2 feet from the property line?
Yeah.
Why do we have zoning laws that say it's 25? We can go round and round with that, but the
Yeah,
bottom
but
line
we
is.
gave variances for that.
No, we didn't.
We never did?
No, I don't believe
The house
so.
is
I don't
usually
believe
there
so.
at the property line if we gave it to him. And I only know of once we did one, we did.
Yeah, well, he has the house there.
It was there.
It's fair.
And we had a
Been there for
case
50 years.
not so long ago where someone wanted to build a garage within, I believe, 4 or 6 feet from the lot line. It was an oversized garage. We said, it's not gonna fly. He came back with a conventional sized garage, 24 by 24, he had like 24 by 30 or 28 by 30.
Yep.
He cut it back, and we negotiated
Yep.
but we said, hold on, at that time, 4 feet was way too close. And I think he got it up to, I don't recall, 10 or 12.
I remember that.
Yeah, but, excuse me, but how many years has this been here? I mean,
Not that
We don't
long.
know. We don't
According
know.
to
It's
7
less
or
than
8,
10.
one of them
It's less
7
than
or
10.
8,
Yeah.
7, 8, right?
With no
Yes.
permit.
with no permit. And had a permit been applied for, we would have had the opportunity to get guidance from the then building commissioner as to where and how he could place that shed, but without a permit, there was
No guidance.
just kind of,
Just some further information. I had asked Maria to contact Henry to find out what the size of these sheds were. So the larger shed is 12 by 16, the smaller shed is 8 by 8. This is an email that came from Henry Lane's
Okay.
office today.
It must be true.
I'm not debating whether it's true or not. I haven't
Don't say
physically been there, so if you would prefer to have a professional surveyor confirm that you're true, then you could do that, but I'm going to assume that it's true.
Excuse me, but what's the new law? State law, what's the new law? 400 square feet? 200 square feet, what is it?
For what, a shed?
Yeah.
You're talking about building, the requirement for a building permit? That still doesn't exclude you from setbacks.
correct.
Is that correct, Mike?
No.
Yes, correct.
Okay.
That's correct.
Have you got the law?
It's anything 200 square feet and over, you need a building permit. But you cannot put any shed in a setback.
Regardless of the size, it has to conform to zoning.
Yeah. So you're right in the fact about the building permit. It is in building code, I've seen it. But you still can't, you have your setbacks.
You can't put it on the line?
No, you cannot.
And you read, it can't be put on the line, right?
No accessory structure can be put in the setbacks. It can be put on the setback line.
It's not in-
If the
it's not in-
setback's 20 feet, it can be put right on that 20 feet, but it can't be put on the property line.
It's not, the building code wouldn't get into setbacks, that would be our zoning.
It would be zoning, correct, yeah.
So why are we going down this rabbit hole now?
No, I'm just clarifying. No, Louis brought this up a couple times and we've talked about it, so we might as well clarify.
I must have read it wrong.
No, you're right, and
If it's
you're wrong. As far as the building permit, you don't need one under 200 square feet, but you still have to comply with zoning setbacks to put that structure there.
We have to make a decision what we're gonna do.
You say so, you read it, right?
Oh, I read it, yeah.
Okay.
So we need to make a decision on how we're gonna handle the request to continue.
You don't want to give
Let
me
me
another
ask
month?
a
For what?
hypothetical
This
question.
thing here.
So?
What would be an acceptable setback?
Oh,
I think we discussed that at last
Yeah.
month's meeting. That, my understanding was if you complied with the front setback, he has enough property to comply with the sideline, and we would be willing to
If
grant
you
a
look on the
variance.
back of that piece of paper I just gave you, I drew a little spot of his map there. So
So-
it'll leave you 23 feet by 530 feet for a buildable envelope to put the sheds. And you get an 8 by 8 and a 12 by 16. You have, I
So you're
think
looking
you
at
have
12 feet.
a lot of space to put, you can spin the thing sideways and still be in it.
Yep.
So 12 feet, I guess, is the answer. That would be a rear setback of 12 feet. And they would comply with front and sideline.
Yep. And
I
be
think
over.
it's more than a fair compromise.
I mean, it sounds like it's gonna have to be moved, period, anyway.
Yes.
So if it's gonna have to be moved, then it can be moved to the 12-foot position. And hunky-dory with the ZBA, hopefully the owner of the property. And actually, the butter is not impacted.
Correct.
That is closer than what we typically.
I know it is.
I know that.
We're giving.
I'm trying to be as fair
We're
as
giving
possible
and
with
trying to be
the
fair, yeah.
situation. It's an awkward lot because it's so narrow.
Mhm.
Yeah, Now it's solved the problem for the abutter.
Yeah.
Solves the problem for everybody, I would
Yeah.
think, but that would be up to Henry's client, I guess. Or the applicant, or whatever.
Are you formally requesting a continuance? Is that?
Well, can I take a 2-minute recess to?
Absolutely, you
I'd be
can.
willing to go with a recess.
Sure.
Yeah.
Thanks, Ed.
Bring my plans. Okay.
They're always gonna move it.
Yeah, you don't have to.
So I asked Ed to contact these people.
Right.
This ain't, am I getting any response?
Yeah, absolutely.
We're gonna need the month to sort it out. I appreciate the board being forth, right about what they would accept, so.
I made the suggestion. I personally feel it's a reasonable compromise.
That was 30 days ago, or thereabouts.
It's been going on for a very long time. Just trying to help to get a resolution to it
I can assure you
that
there's
everybody would be.
places I'd rather be than here.
Yeah.
So they wanna go to court with it, right?
That's not even,
No.
that's not even up for discussion.
No.
I'd go.
And as Attorney Lane knows, there's very few appeals of variances that prevail.
But every once in a while lightning strikes.
Yes.
Right.
That's true.
Go ahead, give him a straw, come on.
I want you to remember that.
Gotta be careful if you're playing with matches and lightning, though.
So then we just need a motion to continue the,
If that's what the board chooses to do.
I mean, for me, it's my last time. We've gone through this for a year.
I think unfortunately, we said that last month.
I know.
And 30 days, I believe, is plenty of time to come up with an alternative plan, especially knowing where the board sits at 2 feet.
I
Wasn't
don't
gonna fly.
understand what's gonna change in 30 days.
I don't either.
Thank you, Mike, for your thought process. I really appreciate it. 'Cause I'm not a builder, but it certainly sounds reasonable, and I have no idea.
Maybe he has a plan.
Well, yeah,
Yeah.
well, yeah, maybe he does.
I think we should give him 30 days.
We've been waiting for that plan for a year.
Up to you.
That's okay. What's a year? Christ's sakes.
Louis waited longer than that.
I've been fighting for 10 years. Federal court says.
We know that.
So far.
We know that, Louis.
So far, the only guy that isn't gonna have to pay me is this guy.
All right, we're gonna-
And you.
Let's stick to the case at hand.
Yes, thank you.
Henry's getting paid, he don't care. So,
What's the board's pleasure?
I don't think I owe him any money either.
I want yours.
I'm not in favor of continuance, I'll tell you that. I think that adequate time is needed in this case. And I think that, I won't be voting for it. I'll tell you that.
It's okay.
I know it is. Go ahead.
Go ahead.
Do what you gotta do.
I say a month, with everyone understanding what's gonna happen, is no big deal. Maybe Henry's got a rabbit in his hat, how do I know? What's a month? What's a big deal?
That's what we said last month.
Yeah, so what? We said it. So what? We said it. But it's words, we said it, but what's a big deal? He's probably working on something. And at this time, he don't have the liberty to tell us. As Sean will tell you, those lawyers are like that, right, Sean? You know, and I say we give him another month, we say, hey, this is the last thing. What's a big deal? A month, 30 days.
We said that last month, Will.
Yeah, we did.
Yeah, I know, but so what? So what? We can say it for another month. Come on, it don't mean nothing. That's how I feel about it.
We know.
You do have a plan, right?
Yes, yeah.
Okay. Says he has a plan. Why would you give a guy, people that pay taxes in this town, the benefit of the doubt?
I think we've been doing that for over a year.
So what? You've been doing me for 10 years.
It's nothing
What's the
to
big
do with the
deal?
benefit of the doubt.
But he says he has a plan.
Well, that's what he said last month. He'd come back with a new
No, he
plan.
was confused last month.
I think he can speak for himself, Lou. So,
So I'll make the motion that we postpone this, Dan Dudley's 219-08, one more month. That would be into October
9th at
9th.
7:15.
I'll second it.
okay, a second. Would you like to discuss this further before the vote?
Yeah, okay.
I mean, I don't know how long we can continue to do this.
I know.
I thought we were quite clear last month that we, and they're coming in with nothing, not even a minor change.
An engineer or trucking company to move it, nothing came in.
An explanation,
Yes. there is
simple
no-
explanation,
Okay.
not there.
Mike, do you have any thoughts?
Oh, I have a lot, but I probably shouldn't share them.
You get 2 votes, right?
Well, we just got, yeah. I
Nobody
made the
else?
motion, you seconded
Yeah.
it, now we gotta vote.
Motions are always made in the positive.
Yep.
Right.
Okay, so we're ready to vote?
I am.
Okay, we have a motion by Mr. Bombara, seconded by Mr. Tassino, to continue the public hearing for, till the meeting next month. All in favor?
Aye.
Opposed?
No.
Abstain.
Abstained. Okay, so the public hearing will not be continued. We want to move forward with your, so we have no choice.
All things being equal, I guess we would take whatever the board will give us.
Okay. All right. I like Mike's proposal.
You want a motion?
Sure.
Johnny on the spot. Mike?
I make a motion to grant him relief on the rear setback. He can go up to 12 feet to the rear property line for case number 2019-08.
Okay, just for clarification, so the motion is to allow him to
Be within 12 feet.
be
of the
within
rear.
12 feet, so it would be a variance of 13,
Okay.
correct? Because of okay. The motion is to grant a variance for 13, leaving 12 remaining
For the rear
for
setback.
the rear setback.
Yep.
And to be compliance with the front and side setbacks.
Correct.
And that's shed number 1?
No,
I think
that's
that's for both sheds?
Okay.
So both sheds would need to be in excess of 12 feet from the rear lot line and comply with zoning in every other way.
The other 3 sides, yeah.
Okay, we have a motion by Mr. Fitzpatrick. We have a second?
Second.
Second by Mrs. Holmes. Further discussion? All in favor?
Aye.
Aye. Opposed? Okay. So your variance is granted for 12 feet.
Thank you.
Thanks, Henry.
What was it that Tina Turner said?
Huh?
What was it that Tina Turner said?
Oh.
I don't know.
You can't always get what you
It was open. The decision hearing. Okay.
What, I guess we're gonna need a motion to close that public hearing.
I'll move to close the public hearing.
Okay.
Second it.
A motion by Mrs. Holmes, seconded by Mr. Bombara to close the public hearing in case number 2019-08. Yep. All in favor?
Aye.
Aye. Public hearing is closed.
So is that vote?
So is the decision
still valid?
hearing.
Yeah, the vote happened during the public hearing.
Never give him a time limit.
Time limit?
Yeah,
And when you do it.
you can wait 5 years.
No, you can't.
No time limit.
Okay. Whatever, I'm not gonna argue with that.
You gotta give him a time limit.
I think he has a zoning violation as of
Building
today.
commissioner,
What
as
do
to
we
whether
get
he
now?
needs any assistance.
Mark, what is your position on,
He's not, he's not.
what was your position on, he got a variance of 12 feet? And at what time would you take action if he doesn't
30?
comply?
When the board tells me to.
Yeah.
That would be after the 20-day appeal period,
They
correct?
already closed the thing though. Can't go back in.
I didn't say I was going back.
No, not going back in.
When do you pass your bar exam anyways?
Passed it last week.
Oh, good, yeah.
So,
You're gonna need it. but-
Anyway.
we'll, at that.
Cross that bridge when we
Next
get to
month.
it. I
Right,
guess.
we can put that in the decision.
Yeah.
We'll speak to
Yeah.
council and
Yeah.
Yep.
have it put in the
Well, how much you
decision.
gonna give?
Hey, can we take care of number 730 here?
Yes, we can.
Thanks.